Okay, finally I fixed it. Oh my goodness. Let's play a little music, right? Let's see if we can. Let's play a little music, right? Let's see if we can. Let's play a little music. Come back in my ears. There we go. I fixed most of it. Okay, I'm back. We're not going to do that again. That was bad. That was really bad. Okay, I think everything's working. We're going to try to jump right back to court, which I show is still not live. I'm just showing. I'm just showing this. You guys see that? Sounds great. Round of applause. We're back. Woohoo! That was crazy. It's one of those problems that I'm confused still. I am confused. It's one of those problems that should not have happened because I checked every single link and everything was right, and so I stopped it and they recreated it exactly the same and then it worked. So it's an issue here. Okay, let's see. I've just turned the sounds back on. Those should be working. If you want to give them a try. Their volume is up as well. No drama needed. Let's see, I can be here as well. Oh, man, that's...
Alex Stollett.
Alex Stollett, thank you very much. Okay, everyone take your seats again. We're done messing with this.
I'm not a cat. Subject matter jurisdiction.
Bring the jury.
Okay. Wow. That is why computer stuff is not my kind of thing. I'm going to figure this out because I need to use this other software, but I'm using hardware and software to do the exact same thing. And then trying to get the two to work together and play nicely was not nice. And apparently the software changed some settings on my YouTube account, which didn't let the hardware work with it, and it was just ugly that way. So, but it's working now. Sorry about the rough start this morning. We are back. Apologize to Bruce McRae, throwing him in the deep end of the internet ownership during my changeover. That's no fun. Okay, so we're back. Do you really need to use the other software? DMB, it's critical for bringing in multiple guests, unless I want to hire someone, because there are too many buttons and things I can manage, and I just can't follow the conversation if I have to do that. So I'm trying to find a solution. If this is not the right software, I'll find a different one. But a lot of,
Thank you, everyone, for your patience. Let's do it.
Let's do it. Thank you, Samantha Terry, once again for a generous super chat this morning. We're good to go this time. We're not going to be, well, let me see if I can show that a little bit better. There we go. Well, nope. Yeah, I don't know why I can't get these to, I need the text to be a different color. That's what I need. Anyway. Back in courtroom, we've got nothing happening as of yet. I'm hoping we'll hear a little bit about the schedule for the jury going on the field trip, which I think will be tomorrow, possibly this afternoon. Depends on how long the... no, it's not going to be this afternoon because it's an hour there, hour back, an hour on scene. Yeah. 6-pack and pretzels are ready to go, says Puzzleman. Love the voice of Samantha Terry. Yes. I'd skip roll call. I have to, really, Richard. I completely made a mess of that this morning. We're no longer live on Facebook, though. PC would work fine. Apple's the king of not working. I agree. This software is laptop intensive or computer intensive because it processes the stream on the computer, whereas currently I process it on hardware. So it's all good. TW, welcome to the gallery in green. Looking great. Looking great. It's good to have that update. I'm not sure why it says welcome to the gallery because I know you've been here before, but we can see from the color of the courthouse, this is month number 3 for you. All right, Emily Baker said jury will go to Moselle immediately at the close of testimony and before closing. Yes, but the close of testimony today might be the end of day, and so it's probably going to be first thing in the morning tomorrow. So when we jump on live, the jury will be out on a field trip. And then they come back to courthouse, have lunch, and then we have closings in the afternoon. That's my idea. If we could just follow that schedule, that would be great. What stream software do you use for Mac? Adam, this morning, the one that caused the kerfuffle was StreamYard. their premium service, which did not work as well. And it's probably my fault. I need to do some more testing and get everything set up. Clearly, the audio routing is an issue because it wants to process audio inside the computer, and I want to process it outside the computer.
Court is now in session. Judge Newman presiding.
Yeah, that was the real one. That was the real one. Did you hear that? Anyway, that was the software I used for StreamYard. And I normally use a Blackmagic ATEM Mini Extreme ISO. Someone's messed with the judge's microphone.
Bring the jury. Good morning.
Good morning, Your Honor. Good to have you here.
Stolen as well.
Your Honor, we were informed this morning by the state that there are potentially 7 reply witnesses. And before we get into
complaining?
that, we've looked at the cases on reply, including State versus Prather, which is a 2020 case. And I want the court, and I want the state to understand, and we think many of these witnesses have already testified. They're not new witnesses. They've already testified in this case, and they're being called to reply to, the way we read the cases, new matters, new evidence, something. We have a right under the case law, State versus Watson, which is a 2003 case, 353 SC 620, 579 SC 2nd 148, to serve rebuttal. To serve rebuttal.
Oh my goodness!
So
You said a right to?
It's discretionary with the court. But
He's like, are you telling me what I have to do?
That under the criteria set out in this case, you would determine that if they raised new matters, that we have a right to respond to those. Now, we're told that Dr. Reamer, their pathologist, is going to testify. And if you remember correctly, Your Honor, and I've looked at the YouTube, that's all we can get at this point, which is a video of it. Dr. Reamer's previously testified that she did not believe this to be a contact wound to the head. I submit they're going to try to repeat that testimony or elaborate on that testimony, and that was the only issue that our pathologist raised, but he believed it was a contact wound, and why. She's already testified why it wasn't a contact wound to the head, and why. So are we going to have to get our pathologist back here to counter hers if she raises some new issue? Or perhaps, Your Honor, I need 7 reply witnesses. It was 2, now it's 4, now it's 7. I mean, this is a process that's got to stop at some point. We're going to be here next week.
It's like it's got to stop. Can we bring ours?
Witnesses that have already testified in this case. Now, one of them I would concede, Ken Kinsey, they're an appropriate reply witness based on Mr. Palmbeck's testimony yesterday. But the pathologist, again, to testify it wasn't a contact wound to the head, she's already testified to that. And some of these other witnesses, law partner members, to testify what they do or do not remember about the night in question. Again, they've already asked them that on direct in their previous testimony. So this has got to end at some point. We spent 2 weeks on financial.
Yeah, he's still
2.5
talking.
weeks of the 6 weeks on financial matters. In my opinion, could have been done in a day. That's just my opinion. But I'd ask the court, as we make objections, to consider and maybe even proffer what they're going to put up before we get in front of the jury, so that Your Honor can make an evaluation before we start down that road for a half-a-day witness that may not add anything to the case. Thank you, Your Honor.
Your Honor, State's certainly aware of the scope of reply testimony as it relates to the pathologists. There are actually a number of issues on which their pathologists challenge the findings of Dr. Reamer, and she's here to explain why those conclusions are incorrect, including his reliance on particular factors, and why ultimately his conclusions are wrong. I think that's directly in the scope of reply testimony. My focus here on reply is not to just repeat testimony, but to focus on specific issues raised during the defense case, that specific witnesses have something that contradicts or puts that in the appropriate context, and that is our focus. We intend to move very expeditiously through that. But ultimately, as it relates to the pathologist, just like Kenny Kinsey, it relates specifically to the conclusions offered by the defense experts. It is not just mere repetition of testimony already received, but comment on factors identified by those defense experts and why those are incorrect.
Your Honor,
Okay. Happy birthday, DMB Secondus.
let's take Mr. Kinsey, for instance. There was testimony
So good to have
yesterday
you
that
here.
our expert believes there were two shooters. Obviously, something that he was not asked. Obviously, something that's a new matter. Obviously, proper for reply. But there are minute details, perhaps, that will be these witnesses will be questioned about. And simply because there might be a hook doesn't mean they get to go into everything. I mean, this is, again, this was an estimate, 3-week trial. We're now in week 6. This will go into week 7. It seems to me the state's position is let no dead horse go unbeaten. This has got to stop.
That's a good sound effect.
Thank you.
Let no dead horse go unbeaten.
The defense, of course, when we had the meeting with Judge
Izzy,
Price,
thank you
at the
so much.
time, we all agreed with
Good
that
to have you
estimate.
here.
It was not just the state. I realize this is going long. I intend to move expeditiously, but the state has the right and the opportunity to do appropriate rebuttal evidence to a defense case, and that will be the focus of the testimony here today.
Your Honor, the right they have is the same right I have. It's the right you allow. I just want to make sure he hadn't got a right to do anything. Thank you.
Anyone's like, you children finished?
Certainly, the state cannot retry the entire case, but the state has the right to reply to contradict certain issues presented by the defense or certain issues of credibility. It has to be finely tailored such that we don't create a situation where the court would be compelled to allow rebuttal, which is almost unheard of.
He's going to want rebuttal if they say anything that disagrees with his
You
witnesses.
mentioned State v. Prather. That was my trial. I was a trial judge in that case in Lexington County, a murder case wherein I allowed reply testimony, actually by a SLED agent. The Court of Appeals, in a 2-1 decision, reversed the conviction. Then the Supreme Court reversed the Court of Appeals and reinstated the conviction that was obtained before me. So it can be a controversial and contentious issue. It almost always is, because there has to be a limit to the back and forth. I'm surprised to hear the number of reply witnesses that the state says that it intends to offer.
Probably going to dig into that just a little bit.
I do not know. The case is so complex. We've had so much testimony. I cannot sit here in advance and rule as to what would be appropriate and what not. I just have to deal with it on an issue by issue, objection by objection basis.
That's his MO. He'll deal with it as it comes up. So bring the first witness and then object. Bring the second witness, then object. Bring the jury.
Bring the jury.
And with that, bring the jury. Love the sound effects today. We're going to get some good ones, I think, out of this one. I'm definitely going to grab Poot's No Dead Horse Goes Unbeaten. That, I think, would be appropriate for so many trials where the information, the testimony has been presented and re-presented and presented again. I think that's a sound effect that just might last and stick around on the page for quite a while.
Bring the jury.
Seven reply witnesses, rebuttal witnesses. Love bring the jury. I've got it turned down right now just a little bit. Now that the jury's coming out, we're gonna dial back on the sound effects, please, just a little bit, because we want to hear what's going on a little bit. Let's see. Vixen, good to have you here. Amber. State must think they haven't proved their case yet. Keep bringing in witnesses. Okay, jury's here, everyone.
Thank you.
You have to behave.
Day number 26. 26. You have heard the defense's case.
Love it, Michelle.
Now the state gets an opportunity to reply. And you may call your first witness.
May it please the court, Your Honor, the state calls
I'm
Ronnie
turning the
Crosby.
sounds off for a little bit. It's been a long trial. Very, very long trial. Let's see if they have to just tell the truth, the whole truth and nothing but the truth, or just swear to tell the truth.
Place your left hand on the Bible and raise your hand. Do you swear or affirm the testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. If you'll have a seat on the stand.
I think I fixed it here, Goodman. Thanks, Nicole.
If you would state your name for the record and spell your last name, please.
Ronnie Crosby, Crosby.
Good morning, Mr. Crosby.
Good morning.
Just want to go over a few things very quickly in reply to some of the defense case. And the first thing I want to ask you is, you had previously testified about your close relationship with Paul, didn't you?
Yes, I did.
All right. And over the years, did you ever have call to ride around the property with Paul, yours or his?
More on my property, but some on one or more occasions at Moselle as well.
What, if anything, would y'all carry when y'all rode around the property like that?
Why? This is about Paul?
In response.
Yes, sir. This will be in specific response to the defendant's testimony and in his statements as well. I can be specific. I don't want to do a speaking response, but I can ask another question and maybe put it in focus, Your Honor.
Okay.
All right. You heard prior testimony that you don't go around looking for hogs in the daytime because they're nocturnal from the defendant, did you not? Are you familiar that was what was said?
Objection, Your Honor, if it's based on what he's heard or seen. I mean, is this a comment made to him, or if we're going to delve into the appropriate way to hunt hogs day or night? I mean, this is not proper reply. I object.
Objection's overruled.
All right. You want me to?
Yeah, if you don't mind asking a question again.
Sure. All right. The first question is, have you gone riding around the property with your property or the Moselle property with Paul before?
I have.
All right. And what, if anything, would y'all carry when you would go riding the property?
I believe the only time I rode with Paul was would have been looking for hogs, and more so on my property.
All right. And what, if anything, would you carry when y'all were looking for hogs?
Objection, Your Honor. Riding with Paul on his property, not Moselle.
Objection's overruled.
Well, people who have hogs on their property, as a general rule, you would always take a rifle with you, be it day or night, because you never know when you're going to see hogs, and because they are such a nuisance, as I spoke to earlier in my testimony, you always want to be prepared to shoot them. So you would generally have some type of rifle and we with you, a long gun.
Objection, Your Honor. He's giving an opinion. He's not been qualified as an expert.
Objection's overruled.
Poot does not
All right.
like this.
You've had plenty of experience in killing hogs on your property?
Yes, I would disagree with Mr. Hart-Pootley, and I am pretty much an expert about killing hogs.
All right. And you've had plenty of opportunity to go hunting with Paul?
Objection, Your Honor. I apologize to the witness.
This is a circus.
And you've had plenty of opportunity to go hunting with Paul or have him hunt on your property?
Yeah, yes, I've been with him, and he's been on my property many more times. I didn't go with him every time he was on my property, but that's the general rule, that you would have a rifle of some sort. Paul, as this jury's been told over and over, was fond of that .300 Blackout. I've been with him while he had it. I usually use some other type of AR-framed gun to shoot hogs.
A 223?
Well, 223 or a 6.5 Creedmoor, which is on a AR-10 frame.
Is it common, though, to carry your rifle and look for hogs in the daytime and to see hogs in the daytime?
Yes. You don't always see them. Sometimes night's better if you're using a night vision scope, but I've killed hundreds of hogs in the daytime riding. It's just something, because there's such a nuisance in the low country and really across the state right now and across the South, that we have a rule that you don't ride the property without a rifle, because you want to try to eliminate as many hogs as you can, and we also trap them.
To your observation, did Alec have a good relationship with the local law enforcement community?
My observation was Alex had a very good relationship with, probably better than the rest of us, saving his father.
Did you on multiple occasions go over in great detail Alec's original story as to what he did on the night of the murders?
On more than one occasion, we discussed his story, as I testified to. I don't know how many weeks ago that was, but it was a while.
And what, if anything, did the defendant tell you about whether or not he checked Paul and Maggie before calling 911?
My understanding of what he told me was that he checked them before he called 911.
And was he clear on that point to you?
That was clear to me.
When was the first time you've heard the defendant's latest story admitting that he was in fact at the kennels minutes before the victims were killed?
I haven't watched all of this trial like a lot of people have, but when I heard that Alec was taking the stand, I believe it was last Thursday, I did set up my workstation so that I could watch his testimony, and it would have been when he told you that he was at the kennels was the first time that I'd ever heard that.
Did Alec ever tell you that he thought the boat case had anything to do with the murders?
Consistent with what Alec told in his testimony, he specifically told me that, and told us that he did not believe that anyone on the boat had anything to do with it. I don't recall any other conversations with him related to the boat case, but he specifically did not believe, and I think that's what he said last week, that anybody on the boat. But as far as anybody outside, there was a lot of speculation going on, but I don't remember ever discussing that with him.
With him?
Right, because we wouldn't know. I mean, everything beyond was, I don't know. It would have been speculation, but I didn't have a conversation with him about that.
Did you ever have a conversation with the defendant about Barrett Boulware needing money because of his illness?
And you're referring to, yes, I did, in I believe it would have been June of 2018.
What was that discussion?
Barrett and Alec were what I consider to be very close.
Improper reply.
The jury's going to get excused here in just a minute.
Yes, sir. The defendant during cross-examination was specifically asked about this particular transaction and that we're about to discuss, and Mr. Crosby's testimony would be in response to what the defendant said about the money, and in as much as he tried to imply that, well, Barrett kind of owed me money anyway, as justification for him stealing money from one of his best friends.
He did not ask him about a conversation he had with Mr. Crosby about that money. This isn't proper reply. This is going off on another tangent.
Overrule the objection.
Can you tell us about that conversation, please, Mr. Crosby?
Yes. And if my year's wrong, but I believe, because I didn't know exactly what you were going to ask me, and I can go back and look at documents, but I'm sure it's in one of these exhibits when that occurred, the materials that Ms. Seckinger put in. I believe in June of 2018, Barrett, who was a good friend of Alec's, a lot closer to me. I think they were, in my perception, very close friends. But I had become friends with him and had done a couple of real estate transactions with him. That summer, I received a call from his son-in-law. Barrett was in the Mayo Clinic with stage 4 colon cancer.
That was not hearsay.
Objection's overruled.
I do know for a fact that he was in the Mayo Clinic being treated for stage 4 colon cancer, and I received a call as to whether I could help Barrett financially.
Your Honor, hearsay, a call.
Objection's overruled.
Because his wife did not have enough money.
Okay, we're going to start watching Boot.
Stay.
This is
Barrett
bizarre.
had some waterfront lots.
Objection, Your Honor, hearsay. All this material came from somebody else.
The objection overruled.
I do know this from firsthand knowledge, Mr. Waters.
He's not supposed
I
to
had
talk.
already bought a lot from him, but anyway,
to
he had a
Boot,
lot
so
that
saying
he
Mr.
asked
Waters,
if
that
I
was
would
right.
buy so that they would have money to be able to, for his wife to stay down in Jacksonville while he was receiving cancer treatments. And I had a conversation with Alec about that.
Tell us about the conversation you had with Alec about that, please.
I just told him, man, it's bad. You know, Barrett's looks like he's going to die, and he did die in September of that year. And he acknowledged it, and he said that it was good what I was doing for Barrett, because he knew that he was in bad financial shape and obviously bad health.
And you're obviously a member of this law firm, and your review of the records as all of this came to light, did that conversation take place around the time that the defendant was stealing some of Barrett's money?
Yes, through this investigation that y'all have heard about into the financial stuff starting in early September of 2021, we started going through a lot of files, and as part of that process, somewhere I determined that in June of 2018, I believe, and I can't tell you the exact figure, but I believe it was a $70-something thousand insurance check that came to the firm on behalf of Mr. Boulware that didn't go through the firm. It was just Alec took it that same month that we had that conversation. And then later there was some more money taken after he died.
Let's see if there's an objection to any evidence here.
We'll show you what's been marked as Exhibit 575. States 575, see if you recognize that.
The sync is just a tiny bit off. We're going to try to fix it here.
Is that David? Is that one of the sled agents?
Do you not recognize him?
Is that David Williams?
Well, I'm asking you.
I believe that's David Williams.
Okay. Your Honor, this time I'd offer States 575 in the evidence.
Objection, relevance.
What is the relevance?
Your Honor,
Picture.
the defendant specifically testified that when he had that initial interview with David Owen on June 8th, as he manufactured his decision to lie about such a crucial fact, it was because he thought that David Williams was the guy interviewing him. This is simply a picture of David Williams. The jury can assess the legitimacy of that claim.
He shouldn't show the picture to the jury. He just turned it.
Never, ever said David Williams. He said David. That's the record. He
Objection.
never said it was that guy.
It's admitted over objection.
He turned it so the jury could see as he's walking towards the jury. He should not be displaying things to the jury before the judge allows it to be admitted.
All right. That's who you recognize as David Williams?
Yes, I didn't know him. I got to know him through this investigation, and I do believe he was the agent that was involved in the case with Chief Greg Alexander that was referenced.
Clearly not David Owen, though, correct?
Well, that's not David Owen.
Look, we have two of them,
tried
two witnesses.
cases with Alec?
I handled a lot of cases with Alec. I believe the only case I tried to jury with Alec was actually here in this courtroom.
Did you observe him being able to get emotional during that closing argument?
Yes, as a couple months ago when we talked and you asked me what kind of lawyer Alec was, and I told you he was a good lawyer, and one of the things that I think I explained to you was that he was a theatrical type presence in the courtroom, and he could get very emotional doing closing arguments in front of a jury.
Thank you. Please answer any questions the defense may have.
I hate to go here, but let's talk about hog hunting, which I know nothing about, okay?
You might not want to go there then.
I've been here so long, I think I probably do need to learn how to hog hunt. But I guess my first question is this. Did you ever ride Moselle with Alec? Did you ride around Moselle with Alec?
Probably. I know I dove hunted there, so I believe I rode on a Ranger, but I don't ever remember doing much riding with Alec at Moselle. But I know I dove hunted there, and sure I rode in a Ranger or some type of ATV with Alec, but I don't have a specific.
Well, when you're riding around dove hunting, you got a gun with you, right?
You would.
Would you take a shotgun to hunt dove?
Yes.
Would you take an AR weapon too?
No.
Why? I mean, them hogs are out there, right?
Well, they don't usually come in a dove field when you're shooting dove. So well, I don't know. You just wouldn't, Mr. Hartpootlian, typically. I mean,
but daytime, you're riding around the property. You got a shotgun. You got a slug in that shotgun, or are you using bird shot?
You would shoot bird shot.
Okay. So if a hog came up, nothing you could do.
If a hog came into a dove field with a bunch of dove hunters,
well, maybe
they would shoot at him regardless.
Maybe you're on your way to the dove field. You don't. The dove field's not right next to the house, is it? It's right within a few hundred yards. Bordered by the swamp.
The swamp's on one end of it, yeah.
Okay. And where do the hogs live during the day, primarily?
Well, they can live in the swamp. They can live in a bay. You know, it can be anywhere, but largely in the swamp.
The swamp. So a hog could have come out of that swamp.
Yes.
And you were unarmed.
As I said, if a hog came in a dove field near somebody dove hunting, they would probably shot it with bird shot.
Would that kill a hog?
If it was close enough, but unlikely.
But unlikely. So you have, in fact, ridden around Moselle without a gun to kill a hog, appropriate gun to kill a hog.
Well, yes, if I was going over to the dove field, I wouldn't have one.
But you've never ridden as Paul and Alec did that afternoon, just looking at different, like where deer, what do they call them? Where they plant stuff for deer?
Food plots?
Yeah. Or looking around at how these fruit trees were doing. Remember the Snapchat video?
I've never done that with Alec, and that I recall, but I could have in the past, but I don't have a specific recollection.
Or where they planted some corn for, I guess you use corn for deer and ducks?
You do, but you don't plant them in the same spot.
No, I get that. One would be near a pond or in a pond or around a pond.
Correct. They had a duck pond.
Right. And then others would just be out where the deer might come out and try to feed. Right. Look, we don't need to go there.
Yeah, I don't think, yeah.
Okay. But you've never rode around like that with them, looking at different plantings and that you remember.
I don't have a specific recollection of doing that with Alex.
Okay, but would you're not telling this jury that they would do that without a blackout? They could. I mean, would it bother you or offend you or scare you that they're riding around the property during the daytime without the blackout?
No, I was answering questions about what's normal if you were looking for hogs or if we were just riding my property. I mean, most people carry a gun, but no, I have no idea what they had with them or what they were doing.
And I think Alec testified they were looking for signs of hogs because you could come back. It'd be a lot easier to find those hogs at night, right? they come out more likely at night than they do during the day?
They can become nocturnal when they have a lot of pressure, but as I said before, we've shot a lot of hogs in the daytime.
Sure.
You can ride up on them and yeah.
But has anybody testified they were out looking to shoot hogs that afternoon?
I don't know what all the testimony's been in this trial.
All I'm saying is there seems to be some implication they would not ride around the property without an AR or some sort of blackout. You can't testify to that, right?
I cannot. Okay.
So let's talk a little bit about what you heard from Alec the night of June 7th. You would agree with me that, well, let's ask it this way. Your practice is primarily personal injury, is that correct?
It is.
Catastrophic injuries.
Well, I handle a lot of catastrophic injury cases.
Cases, for instance, where a husband and wife are riding down the road and hit by a tractor trailer. And by way of example, maybe you could give me something more specific. Husband's killed, wife's severely injured. That kind of thing.
Yeah.
Now, is it your experience in people who undergo, maybe they're not hurt, but their loved one is hurt, maybe killed, in that situation, that's a traumatic experience for the surviving person, correct? To see their loved one killed?
Yes.
Okay. And so when you sit down with those folks and begin to recount with them what happened that night, oftentimes, I do a little work like you do, oftentimes those folks misremember or get times wrong, or because they went through this very traumatic experience, and the closer to that experience, the more likely they are to get some things wrong. Times, for instance. Is that your experience?
They can, but I also find that people who have been involved in traumatic experiences try to be very accurate with the details because they know it's important to me representing them.
And typically, you don't go out to the scene of the crime and interview, or the scene of the accident and interview them that night, do you? Typically?
Well, typically you don't because you don't know it. It's happened.
Well, sometimes in the old days they used to do that, but they don't do that anymore, right?
That would be very rare.
So you're seeing them in your office weeks later?
It can be days, can be weeks.
Okay. And in that atmosphere, it's a little more conducive to them being as accurate as possible, right?
It is, but oftentimes we also have the benefit of recorded interviews when there's a catastrophic injury. Typically, the highway patrol will try to interview people as quickly as they can, and they will. We oftentimes have it on video off a dash cam or sometimes body cam, but and a lot of times written statements.
And written statements from witnesses that saw it happen.
Correct.
And so when you interview those people, they have the benefit of reviewing whatever you have to help them get a better recollection of what happened, correct?
That's correct.
Okay. So the instance you're talking about where Alec told you he turned him over before he made the 911 call, whatever it was, I'm not quite sure. Before, I think is what you said. If that would be inconsistent with something he says later on, after having reviewed other people's statements, looking at video, that would not be unusual in your business. I think you just said it would not be unusual, correct? Look, strike that.
You're trying to take me somewhere that you probably don't want to.
Oh, no, I think I want to.
Answer the question.
Withdraw the question. Let me ask you this question. Maybe let's get to the meat of the matter here. Have you had to come out of pocket to pay back the money he stole?
Yes, and if you...
How much? Don't tell me you don't know.
Well, we're still counting, Mr. Hartpootlian.
Well, how much have you paid so far?
We have had to borrow millions to pay back.
No, how much have you had to come out of pocket?
Well, when you borrow it, you got to pay it back, and I couldn't tell you how much has exactly been paid back as of we sit here today. But yes, and if you're implying that I would come in here and somehow shade truth in any way because of that, I would take high offense with that, Mr.
I'm not
Harpootlian.
concerned about your high offense. Are you angry at him for stealing your money?
I have no feeling one way or the other.
I don't have any feeling about Alec Murdaugh betraying you and stealing your money. I admire you. I don't know that I could look beyond that.
Objection, Your Honor.
It's sustained. There's not a question. The jury is to disregard the argument.
You are not angry with Alec Murdaugh?
I have had anger with him, extreme anger, Mr. Harpootlian, because of what he did to my law firm, my partners, my client, his clients, our clients, what he did to his family, what he's did to so many people. Yes, I experienced a lot of anger. But you can't walk around with anger. You have to find a way to deal with it and move forward. And I have done that. And if you suggest you are dead wrong if you think I've come in here and told this jury something because of money, when we're talking about two people who were brutally murdered, then you're headed in the wrong direction.
Do you think he did it?
I don't have an opinion. I don't have the benefit of the materials you have.
Well, let me ask you this. You're angry with him, stole millions of dollars from your firm. You admit your firm's not even called the Murdaugh firm anymore, right?
It is not. I don't admit that I'm angry right now. I told you I've gotten away from that. I don't have any feelings because you can't walk around with anger. I have been very, very angry about it because of what he's done. And he did it in a very callous way, a very deceitful way.
And you carry no, I'm sorry, maybe I just saw some anger there. Were you angry just a moment ago?
No, you keep trying to push a question and don't want to accept my answer, which is what it is.
That you've just given your zen, your nirvana, your whatever the...
Your Honor, objection.
Mr. Harpootlian,
forgiven him?
I came to the scene of these murders to support my partner. I was there. I saw things that hadn't even been talked about in this courtroom. I was there. I love Paul very much. I thought I knew who Alec was. I did not. And it's hard to you might not understand, but it's hard to walk around with anger, and hard to even walk around with it when it's with somebody who you didn't know and didn't understand. So you might have be that way, but you know, I've got to function, I've got a family, I've got to move on with life.
Were you aware that he went to rehab in 2017?
I was not,
Really?
other than what was said by Alec in this courtroom.
You never were aware he had a drug problem?
I was unaware.
Okay. Sort of.
And if I would have been known, I would have tried to help him.
You indicated that he could be emotional in trying a case, correct?
He could be. He was theatric, much like his father and grandfather had a courtroom theatrics, and he could be emotional.
Any of your other partners that way? Johnny Parker?
No, Johnny's quite the opposite. Johnny's very
Laconic, I believe, is the best way to describe him.
he doesn't show emotion.
Nobody else in your firm was theatric or emotional?
Not to Alec's level.
You don't know any other lawyers in the state that go to that level?
You're asking me a question right now. I don't know. You might yourself. I don't know. I don't know what other lawyers do. I'm usually trying cases against defense attorneys, so I don't get to see plaintiffs' lawyers anymore.
Okay. Well, I want to thank you for. Well, let me ask you one last thing. This Boulware guy that he stole all the money from, Mr. Boulware, remember him?
Yes, I remember him.
How much money did you steal from him? Do you remember?
He stole $70-something thousand in June of 2018. Mr. Boulware died in September, I believe, of 2018, and I believe another $270-something thousand after Mr. Boulware's death, sometime in or around February of 2019.
Have you and your partners paid Mr. Boulware's estate or his folks back?
Yes, I met with them personally.
Okay. And even though it's cost you your firm and it's cost millions of dollars to you, you have forgiven him? You bear him no ill?
I didn't say I forgave him.
You're just not angry about it anymore?
I said I have no feelings. And I had to work on that, Mr. Harpootlian. You know, when you go through what we've gone through, not only the trauma of losing people we loved in a double homicide, seeing the aftermath, and then learning that someone you worked with for more than 20 years had been stealing throughout a period of time and deceiving us, there's a lot of emotion there. And yes, it was bad in the fall of 2021, and I have found a way to have no feelings. It's not forgiveness, it's just I don't have any.
You're not angry here today? You're not angry at him at all?
I'm not angry. If I raise my voice, it's only because of the implication that you were trying to
The
make out of
implication
it.
that you might not want to help him in front of this jury here today because let me finish the question, because he destroyed your firm, he stole millions of dollars you had to pay back, he deceived you. All that's away and is not influencing your testimony here today at all. If you'd answer that yes or no, then you can explain.
All those things happened, and it does not influence my testimony. I take the oath that I just took very seriously. And if you've got any indication that anything I said was inaccurate, I'll be glad to address it with you.
Well, the jury can judge that. Thank you.
Yeah, don't leave. It's gonna get crazy in here today.
How long did you know Alec?
Since the late 90s.
And knowing what you know now, was he able to look you in your eye and lie convincing to you day in and day out?
He did.
And was he able to look juries in the eye and display emotion?
Objection, Your Honor. That is not appropriate redirect, and it's leading.
The objection is sustained.
Was leading.
Mr. Harpootlian asked you about some of the things that you have gone through. And is your issue with Mr. Harpootlian's questioning the implication that you would come in and shade things in front of this jury?
Objection, leading.
What is your concern with Mr. Harpootlian's questioning of you? Can you express that to the jury, please?
Is that proper?
All that he just went through with you, sitting up on the stand, having to deal with this, what is your problem with what he was trying to say?
Well, I fortunately, to start with, I took an oath to tell the truth. But we as lawyers also have oaths and obligations to a court. And it goes a lot deeper than just that oath. We are bound by rules of professional conduct, ethical rules that I take very seriously as a lawyer. To my knowledge, I enjoy a very good reputation as far as being a person of integrity. And that's what I took issue with, is him attempting, because he cannot impugn my integrity.
That's fair. Would you take a .22 if you went out looking for hogs?
Possibly a .22 Magnum, which is a long rifle.
Which is a long rifle?
Yes.
You take a long
I had
rifle,
a
not
.22
pistol,
Magnum
is that
pistol.
correct?
Yeah, I would never. I'm not a good shot with a pistol, but I would never take a pistol.
And what was Paul's favorite gun for shooting hogs with?
Asked and answered.
I knew he always had a .300 Blackout, but I don't know if he shot him with anything else.
Thank you. Nothing further.
Anything further?
I'm sorry, Your Honor, I just can't leave this alone. Is the .300 Blackout that's in evidence his favorite? The .300 Blackout with a thermal scope on it?
Yes.
Okay, thank you.
Step down. We call your next witness.
Your Honor, the state calls Dr. Reamer.
The good news on these is most of these witnesses should be very fast.
Do you swear or affirm the testimony that you give today will be the truth,
So
the whole truth, and nothing but
it
the
almost
truth?
guarantees a spicy day.
Thank you. Can you have
I
a
think
seat
we're
on
going
the
to see a
witness stand?
similar level of objections, very animated objections throughout all these
Spell your last name for the
all these rebuttal
It's
witnesses.
Dr. Ellen Reamer, R-I-E-M-E-R.
And just to advise the gallery, if everybody could seal the monitors, please, and the media be advised of that.
Just my opinion, we are in rebuttal. So the state is offering, they've said 7 rebuttal witnesses. One of them will be lengthy, and the rest will be fairly short. I think the one we just saw was short. Medical examiner is
Dr.
back.
Reamer, I want to move through this. Yes. And Dr. Reamer, I don't know if I'm necessarily even going to put them up on the screen. I am going to show you some images. I know the jury have seen these, and I don't want to belabor the point, and I want to move quickly. But just very quickly, you've been previously qualified as an expert in this trial in forensic pathology. Is that correct?
Yes.
And you've done how many autopsies? Remind the jury, please.
What's Poot walking around
Around
for?
5,500. Since I was last here, I've done a few more.
Excuse me. I can't see a monitor anymore.
Okay. I haven't put anything up yet.
Poot's like, I can't see a monitor anywhere, so I'm walking in
You
front of
actually
the...
conducted the autopsies of Paul and Maggie in this case?
Yes, I did
haven't put anything up yet.
both of the autopsies at the request of the Colleton County coroner, who called MUSC Forensic Pathology, requesting autopsies on 2 individuals that died under his jurisdiction. I was not asked by the prosecution to perform an autopsy. It was an independent autopsy.
Your autopsy is independent. You're not hired by the prosecution or law enforcement or anything
No,
like that?
it's just at the request of the coroner.
All right. You've had a chance to hear the testimony of the pathologist for the defense that testified yesterday?
Yes.
All right. I want to ask you a couple of general questions and then move specifically to some of
all the
the
witnesses.
conclusions that individual reached. But just very quickly, with skin tags, can you tell me the reliability of that in determining directionality just as a general matter?
Yeah, well, we look at these things, but just like every other thing at, finding at the autopsy, we take it in the context. So sometimes skin tags support your findings, and sometimes they're not really so reliable. So, skin tags don't tell you necessarily the direction of a wound, especially going through very soft tissue.
All right. And I'm going to show you a couple of exhibits that have been previously introduced in this particular case.
Poot is standing so he can see these exhibits that are going to be presented. All the monitors are closed up because these are sealed, they're graphic, they're autopsy or crime scene pictures. That's why he's over there. And he's gone.
I'm going to show you what's been marked as exhibits, defense exhibits, 159, 160, and 161. And if you could take those out and just tell me if you recognize those. And again, please be mindful of the direction in which those images are presented. Excuse me. I'm sorry.
There's so little room. They're stepping on each other's toes as they walk around the
Yes,
courtroom.
I've seen these.
All right. And what are those images of?
They're autopsy photographs of Maggie.
All right. You heard the testimony of the defense pathologist who testified yesterday that the directionality of the injury to the side of Maggie's head with the associated injury to the breast and the abrasion actually was coming from the top down as opposed, and I say top down as if somebody's standing upright, as opposed from going towards the bottom of the body up, correct?
Yes, that's
All
what I
right.
said.
And can you please look at the images that you have and explain to the jury your conclusions and why that defense pathologist is incorrect, who didn't conduct the autopsy to begin with, why he's incorrect?
Okay. Do you want me to show the photos?
You can, and let's just go ahead and put them up on the screen. So I'll take them. And if you could step down, please, if that's okay with your honor.
Brooklyn, that's funny. For those that don't know, Poot is a senator
First,
in the
I'm
state of
gonna
South
show
Carolina. A state senator.
Defense Exhibit 160. Are we secure?
And Creighton is has a cover band. He plays the guitar and I believe sings as well.
All right, and that's Defense 160. And Dr. Reamer, if you can again explain to me your specific findings and how they relate to the testimony from yesterday.
Yes. So we have the abrasion on the left shoulder, clavicle area, and then we have an entrance defect in this left side of the face. We can see a hole there. It's a hole. And there was a defect in the left temporal lobe of the brain, which was included in my autopsy report, that could only have happened from that being an entrance wound.
Okay. And you mentioned during your testimony the concept of a diastatic fracture. Does that in any way relate to your conclusion in this regard?
Yeah, well, a diastatic fracture is when there's a separation of skull bones along suture lines which solidify during childhood. And usually it takes a lot of intracranial pressure to fracture a skull along the suture line.
All right. And does that relate to the conclusion that this had to be an entry wound?
Yeah, well, that's a finding. That doesn't prove that this is an entrance wound, but what I do, I have a path through the left temporal lobe, and there's, that it was associated with the diastatic fracture because of the increased pressure.
All right. And one of the things you're telling this jury is you who actually...
Objection leading.
Were you actually able to observe a hole associated with an entry wound when you physically performed this autopsy?
Yes, I physically performed the autopsy, and the way I determine direction is I have a hole below the left ear, which went into the brain, and so that's not going to happen in the opposite direction. And I understand that people can look at pictures. That's like a two-dimensional view, but doing the autopsy makes certain information available to the pathologist that is not available to an individual not performing the autopsy. And I had that information in my report, which was not, which was, I guess, overlooked.
Overlooked by the defense pathologist.
Yes, I'm sure.
All right. I'm going to show you now Defense Exhibit 161. And there was some testimony from the defense pathologist about trying to determine directionality from this particular image. And can you please tell the jury why that pathologist is wrong?
All right. Well, when we have tears of the skin, and this is a lot of tears of the subcutaneous tissue, especially in the very soft area of the body where there's a lot of fat. There's a lot of stretching, and it doesn't necessarily, we can move the tissue of the breast, and sort of, you can even get the points to go into a different direction. This is not very impressive. It's not even really worth observing any of the skin tags. It's really very non-specific, and I think he has a very good imagination for seeing that in this photo. And it's, skin tags can be there. Sometimes they support your findings, sometimes they don't support, but they don't take the place of determining the path of the wound by actually following it through the body.
I'll show you finally what's been marked as Defense 159, and is this also a representation, sort of the hole that you determined and were able to physically observe as a entrance wound on the side of Maggie's head?
Yes.
He said finally. Does that mean they're done?
All right, let's talk a little bit about
finally on that topic.
Paul, and you heard the defense pathologist and their subsequent expert talk about there being a contact wound to the top of Paul's head. Is that correct?
That's what he said.
All right, and you, of course, have already testified during your direct testimony that there's no way for this to be a contact.
Thanks,
wound,
Ivan.
But now you have specific observations about the defense conclusions.
Well, I didn't think it was necessary for me to point out every feature, physical feature of the wound that demonstrates that the entrance was to the top of the left shoulder and then went into the left side of the head before exiting the top of the head. Now, before I go on, I do want to say that I agree with the book that keeps being brought up, that when there is a contact shotgun wound to the head, there's massive gas expansion within the cranial cavity, within the skull. And what that does, it doesn't just create a hole with some, bones. I understand this was like the most severe thing you have ever seen. And you probably can't imagine that the damage to the head could be any worse. But a contact shotgun wound to the head with the associated gas expansion to the skull would not have, his face was basically intact. We would have had tears of the skin, and his eyes would have been either displaced from the orbital bones. The orbital bones were intact. Anytime there's massive gas buildup within the cranial cavity from a contact shotgun wound to the head, which the book does say is when we have the worst gas expansion, the entire face, he would have not even had a face left. I mean, I know what you saw was awful, and it was absolutely awful, but the damage would have been a lot worse. He would have had, the sides of his head would have down, and he would have had, his entire face would have been split open, because there's no way all of that gas expansion could occur and not cause fractures of these delicate bones in the face. His forehead was even still there. So, I agree with the book that a contact shotgun wound would cause severe gas expansion and damage to the head. What we have here is not consistent with a contact shotgun wound to the head. The damage to the head would have been much worse, even though this was already horrible. Okay, that being said, there are photographs. Okay.
Yep, and I'm going to put up what's already been admitted into evidence as States 486. And if you could, Doctor, just talk a little bit about this image as it illustrates what you're talking about with the face, but also, if you could, we'll go ahead and talk about with the face, and then I want to talk about the shoulder a little bit as well.
There's no skin, torn apart of his face. His eyes are still in the correct locations. It's hard to imagine that, anything could be worse than a hole at the top right side of the back of the head. But in my 20-plus years of experience doing autopsies and seeing contact shotgun wounds to the head, which are associated with massive gas expansion in the skull, this entire face, he would have had tears. The eyes would have been either hanging down or lost, blown out. There's no way that these features are consistent with a contact shotgun wound to the head.
All right. Now, there was some discussion by the defense pathologist about shaving the top of the head for stippling or checking for stippling. And can you comment on the necessity of that in your actual autopsy that you conducted?
Okay. So, he also said that sometimes we actually don't see the soot. Like he said, if Dr. Lima shaved the area, she would have had the opportunity to see the soot. So suppose I didn't see soot, or I did see soot. First of all, I'm confident there would not have been soot, because the features of this wound are not consistent with a shotgun wound to that location. First of all, the damage to the head and face would have been far more severe than it was. And then also the wounds to the shoulder and left side of the cheek. I don't know what Pete's reading. The features.
Maybe that same book she's talking about.
All right. And one of the things discussed by the defense experts was sort of the large sort of oblong shape of the shoulder. Can you explain how that does not contradict your findings of that shot coming this way, that we see this injury here? And I'm going to actually put up Defense Exhibit 162 to illustrate what I'm talking about.
The pellets embedded in the shoulder is the most critical point she needs to address.
So we've got basically an oblong wound here, and that's because the wound is entering at an angle along the top of the shoulder. It's not hitting the shoulder at a perpendicular angle. So it kind of grazing along the top of the shoulder. Okay, now is this, okay. So, and actually, he said that the pellets are going down. Okay, well, if you look at it as an entrance wound, they're actually going up. So it depends where you're looking at it from. If he's thinking that this is an exit wound, that this is, that the end of the wound path, then it would look to him as if the pellets are going down. But we can see this is actually an entrance wound for a few reasons. First of all, if it were an exit wound, do you remember all those pellet exit wounds on Paul's left arm that came from the chest? The pellets are not just going to stop in the shoulder. There's like no resistance there. The pellets are going to continue going until they exit the left side of the arm. Okay, so they don't just stop there. The reason they're there is that's because they started there. Okay. In addition, you see all of this white material here on the edge of the entrance wound. That's styrofoam packing material that's between the pellets. So the pellets are contained within wadding, and there's styrofoam packing material between. And that would never have been deposited there. So I did not think it was when I was telling you the direction, my determination of the direction of this wound. I did not have to necessarily. It was my expert. I'm an expert at determining forensic pathology includes establishing the direction of wounds. And because of all of these things, this was my determination. Okay, now there's another feature of this photograph. Do you see that this is coming into the left side of the, this is what I determined, left side of the cheek, and we've got all sorts of abrasions around here. Now it doesn't
I believe both bodies were
classic,
cremated.
What we saw on Paul's chest had those little petals, so we knew that the wadding was starting to open up. But in this case, there was wadding that was probably open as well. So we have some pellets already starting to come out. It's not entering within the wadding, but the wadding is going along and entering them. And we have all this abrasion around the left side of the cheek, the chin neck area. And that's consistent with, we're not going to have that abrasion if it's coming out. If it's going to push the skin out, we're not going to have an abrasion. So, all that but even just common sense, we have that styrofoam packing material on the outside of the arm. My determination, this went up through the left cheek, out the right side of the top of the head. If it were a shotgun entrance wound, contact to the head, I don't care whether there's no way his entire facial bones and skin, his ears would have been flopped down. There's so much gas expansion that the damage to his head would have been much worse. So that's based on my experience for doing this. And, I just don't know how. I didn't mention that styrofoam packing, but that's from when the pellets are coming in. And he said, oh, you can see they're going down. That's because he's looking from above. So but if you look at where I believed and I determined by doing this autopsy that the entrance wound is, it's actually going up. So it depends which side of the pellets you're looking at. And if just logically, if this was an exit, the pellets wouldn't have just stopped there. They've got a huge amount of energy. They're going to continue through the arm and have individual pellets. They wouldn't have all just been concentrated right there. So, we can use our powers of logic, which I think, we all have, to understand how this is an entrance wound that exited the right side of the top of the head.
Dr. Reamer, having specifically, and you can take a seat now, thank you very much, having specifically addressed the specific criticisms of the defense pathologist, in your expert opinion, having actually done the autopsies in this case, is there any way that could have been a contact wound to the top of the head?
No.
All right. And having addressed the specific concerns of and testimony of the defense pathologist as it relates to Maggie, is your conclusion still that the shot went in the direction as you described before this jury?
Yes, I disagree with his conclusions.
All right. Thank you very much, Dr. Reamer. Please answer any questions the defense counsel may have.
think she's going to get hit with some things out of the book, that she does not agree with, where she said she did agree with the book, and now she's going to say she doesn't agree with the book. So let's see how well Poot can present this, because I think he can get her in a tight spot.
Dr. Reamer, good to see you again.
Hello.
So, you took pictures, correct?
I took pictures. I wish I took more pictures now, but I took pictures.
I'm sorry.
Yes, I would have. I wish I took even more pictures.
So do we.
So do we.
So,
yeah. That was a good line.
You made notes, which you converted into an autopsy report.
Yeah, it's a standard operating procedure.
Yeah, no. But so, and that's done so that somebody else can look at your work and see if they agree or disagree with you. Because
no, the notes are a work product for me while I'm preparing, doing my examination. I don't always, I take notes, I write numbers, but that is really for me so I can incorporate findings into an autopsy report that I'm going to write. And I don't write it the same while I'm at the table. I need to go away. Maybe I'm going to do it the next day, that night. So, but it's not done. People say, oh, can I have a copy of the autopsy diagram? Well, these are not autopsy diagrams that are meant for other people to look at, and sometimes they're not even completely accurate because I mark things on the outside of the body that later on during the course of the autopsy I determine, I'm like, oh, well, that's what that is. And it may not be what I initially wrote down. But by the time the autopsy's over, I've put it all together. And that a diagram or notes do not necessarily reflect everything, that I concluded.
Do you still have your notes in this case?
I imagine they would be in the file, but as I told you, this is my notes are not necessarily the conclusion that I came to.
Did you produce them to the state?
I don't know what I did. I personally, if they were asked for, I'm sure I did.
Did you produce them to us?
No, I don't remember producing them at all. I don't have a request for those notes in my file.
But those notes would be your present sense impression as you're doing the autopsy, correct?
Well, they can have a lot of things written down on them.
But we don't know because we didn't get them, right?
Well, they're not important. What's important is they're my notes. They're for me. They're an aid to the pathologist. So even if I thought something initially, and then while I do the autopsy, by the time I get to the end, it could disagree. I don't necessarily go back and change the diagram. It's my work product. It's for me to aid me in writing my autopsy report. It's not for public view. It's not a.
Okay, so you just go with your report.
Well, I reviewed my report, correct.
Right, but
the
you don't
audio's
go back
way
and
off here.
your
Let me
No.
get this back.
So let me ask you some basic questions here. You've previously testified that the muzzle of the shotgun for this wound here that goes through his neck and out the top of his head was about 3 feet away.
That would be about right.
Okay. Now, you're familiar with this page from, I believe you've described it.
Oh, yes, I've seen it many times.
Okay. And as you see, the gas comes out.
It's a trap.
Right? In the first shot, the top
Yes.
shot. And then actually there's sort of a blowback of gas as as we can see right here, the projectile, which is the pellets, are extruded from the barrel, right? I mean, the gas pushes the pellets out.
Well, there's gas expansion, and that helps propel the pellets, yes.
Okay.
I agree with the book. This was not a contact shotgun wound to the top of the head.
Okay, well, the book doesn't say that. But what the book does say is that as the pellets come out, at some point they begin to, the container opens and the pellets expand or move out in a pattern, a circular pattern. It becomes bigger as the further away you get, correct?
Yes, and that's what we have here.
Okay,
But this is actually demonstrating specifically a contact shotgun wound to head. But we do have splaying outward of the pellets. We can see on the left shoulder they're fairly clustered together because they're first starting to be released from the wadding. And they did spread out. We have some of them down in the neck, some of them in the brain, and so they are spreading out. I don't see how, yes, it's a respected treatise, but this is specific to a contact shotgun wound to head. This is what this is describing.
Really?
Well, it's fine. It doesn't matter. I can look at my photos. I can look. If you're going to talk about theory, the photos.
Doctor, Your Honor, I would ask you to tell the witness to be responsive. She is going on a diatribe. Excuse me. I'm asking the court to instruct her to answer the question as specifically as she can. She goes off on tangents, and I'm sorry.
All right, Pruitt, you may continue answering the question.
You remember what the question was?
No, that's your question.
Is this series of shots from the book depicting a contact wound? I think that's what I understood.
Yes.
Yes. Okay. So where, if you step down here, show me, please, where the contact is with the body or the head. Here, let me give you this pointer.
Well, the contact would be at the first area.
Right here?
Yes.
Well, what's it contacting?
It's not. It's just a theoretical depiction. It's a theoretical.
Is that what the book
depiction.
says?
Yeah. Well, go ahead. I don't recall the exact. Why don't you read it to me?
Well, why don't you tell me? Is that a contact wound?
I don't know what this is. This is.
That's a shotgun.
That's a shotgun.
That's a shotgun being fired. Those are the pellets coming out.
Object
Those
counsel
are the pellets.
testifying.
Yeah, I think this is a book showing the series of steps after a shotgun is fired. But it has nothing to do with what I found in the body and does not help me determine the direction of the wound.
All right. So,
and I'm not going to describe to you. You can read it in the book. I don't remember how he says all of this.
The book isn't testifying. You are. You've testified that depicts a contact wound. Yes?
Well, I don't know what this is depicting. It could be that this is a contact wound. I don't know where you're going with this.
Well, here's where I'm going. Is that barrel in contact with anything?
It's not in contact with anything. It looks like it's just blowing into the air.
Okay, and you've been. That's fine. And your testimony is that barrel is at least 3 feet away from Paul's shoulder. Is that correct?
It could be, depending on the weapon, it could be, it's not closer than 2 feet because we don't have the sibling. But we do have packing material.
Okay. So, as we see here, these pellets are beginning to separate. Is it your testimony that those pellets had separated when they hit Paul's shoulder at all?
They are starting to separate. We don't have the complete, widening of it. They're still relatively clustered together, but they're not as close as they would be if they were still contained within the wadding.
Okay, now, at 2 feet, is there any gas left, or is it all dissipated like this picture shows?
Well, what we have here, if there was more gas, if there was a contact wound to here,
it's not a contact.
I understand. The gas, you're wanting me to say yes or no, and
yes
I can't
no.
Because I have the knowledge to explain how this relates to examining the body.
Okay,
I don't give theoretical talks or I don't start looking up in this book while I'm doing an autopsy. I use my practical reasoning and my experience and knowledge of things.
If there'd been gas in the wound, or when it hit his shoulder or his neck, would you expect to find some physical manifestation of that?
Well, there would have been, a lot more expansion, shoulder expansion. This was fairly contained on the left shoulder.
Your testimony is there would have been little or no gas going to his shoulder, to his neck.
Well, there is always some gas, but it's not the kind of gas that we get in a contact shotgun.
Exactly. So, and you can go ahead and take the stand.
This is a problem because she says the gas from the blast is what caused the the head injury on the top of his head. So now she's saying there's no gas there. We'll see where he goes with this. He's set up to really put her in a tight spot and could get a big win on this. Poot may get to score some major points.
No, not that one. Paul. Paul winning that one.
I don't remember the number off the top of my head. It'll be over there somewhere. 160 something like that.
Ladies and gentlemen, I have you go to the jury room for a break. Please do not discuss the case.
We get a little bit of a break. Nicole, I'm not sure if you want to hop in. I'm not sure what your schedule is. Or Matthew, I've got Zoom up, so we can bring whoever's able to jump in if you're able. It depends on your schedule. Charlie, thank you very much for the gifted membership. Looks like the membership went to, I can't see. Oh, Hannah, congratulations. Thank you, Charlie. Amazing support yesterday and today as well.
Down, please do not discuss your testimony with anyone. It'll take about 10 minutes.
Got about 10 minutes. Let's see. Way too emotional to be a good witness. She did get rattled. She was taking it personally on so many fronts, and that helps. That helps the defense quite a bit because she also wants to explain. She wants to talk. She's got this free spool. I have to say more issue, and really, I think a couple of you pointed this out. Creighton probably should not have put her back on the stand. I realize he has to counter some stuff that came, but. As far as the top-down shooting. But I think he probably could have done that better from a logistical, how could the shotgun do this type thing? What position would be, is this reasonable up front, than taking her on the stand. She was not good the first time. I know some of you say you really like her. I don't think, as far as Emmys go, she does a good job explaining things without getting too technical. But I think she's also a little bit of a loose cannon. So, yeah, we'll see. Let's see. Putin needs to sit and wait his turn. Let me double check and make sure everything's running properly. Start that. We're good there. Okay. Awesome. She seems scared. She seems offended that this other examiner came in and had a different opinion than her. She seems like that was not making her very happy whatsoever. I think she's heightened but not emotional. I think the jury will like the way that Poot talks. I think the jury won't like the way the Poot talked down to this lady. I know she's an expert. Yes, same Zoom info. I keep it the same for security reasons. I change my passwords when needed. One Man's View just gifted a membership from Charlie as well. Thank you, Charlie. It's great to have you here. Charlie's a good friend. Been here a long time on the program. Great support. Let's see. She is very ticked, and you can tell from the way she's talking. I think she probably needs to. I mean, not eat a Snickers before each answer, but just stop and think it through. And it seems like she wants to be right so much that she's coming off just a little bit too quickly. And Poot sort of caught her in a trap with the book about the picture. And she's like, you don't know what that is. This is what it is. She says it. And apparently she was wrong. She's like, this is describing a contact wound and everything. And it wasn't. Now she's like, that's not what I'm talking about. It doesn't matter. The book doesn't matter, But she's said so many times, I would agree with the book. I would agree with the book. And now Poot's pointing out that she doesn't know what the book says. New trial starting today. We're going to be sticking with this one for a little bit. We might have to catch up on that one, Lily. We'll have to watch that one. Wisconsin versus Zachariah Anderson. Huh? Is that a retrial? Might be interesting. I thought it was funny when the opt said, well, the book is testifying. It's not testifying. You are. Hey. I hear voices in my head.
Sorry, I had to do audio this morning.
All right, we'll take
On a
audio
different
only.
time zone.
Yeah, that works. How are you doing, Nicole?
I'm good. I'm good. Thank you for having me.
Awesome,
So,
awesome.
fiery day in court today.
Yes, we expected it sort of, though. I mean, as we get towards the end of the trial, people's opinions are more solidified. A lot of evidence has been formed. We're sort of taking sides, so to speak, and as we get further, and now you'll see it in chat as well. Just just the discussion. People are more animated as they talk about all the things, as we're more educated based on our different perspectives. What today did you specifically want to talk about? I know you talked about the Fifth Amendment objection, which you think the defense should have made but hasn't. Do you want to talk about that briefly? We've got probably 5 or 6 minutes before the judge comes back.
For sure. Yeah, that's a quick one. So initially, when Waters started questioning Alec regarding his what he called his new story that he made up in court, and the defense objected, they argued Fifth Amendment, and the judge overruled it. But he wanted to put something on the record. Pardon me. I don't think he ever actually did. He didn't elaborate on it. But there's substantial U.S. Supreme Court case law and South Carolina case law that is crystal clear. It is prosecutorial misconduct and reversible error to suggest that a defendant who has invoked his Fifth Amendment right has falsified, created, or made up a story because they're testifying about it for the first time.
Okay.
So if anything, if the defense, was concerned about that, and it even came up today and there was no objection. There has to be an objection. Without the objection, there is no appellate issue.
So they need it for appeal. What they said before is not enough.
No, I mean, he brought it up at one point, or I think he did it twice. If I take that back, I think he did it twice the other day. But every time that it comes up, he needs to renew that objection. So, for example, when Waters today made a comment during his question about his story being told for the first time, or this new story or something like that, that's when he needs to make that objection, because it's inferring that he's guilty because he didn't say it before. When you invoke your Fifth Amendment rights, it doesn't matter what you've said before. Whatever you say after, you cannot use that silence.
Right. And that never should have been brought up in front of the jury. That's basically,
right.
That's the point where they should have said mistrial, right? Call for mistrial. Yes. And
yes, they should have said, you know what, it went too far the other day, and now here we go again. And the prosecution is trying to imply that he's lying because he remained silent until he testified. And that's a problem. Now, I know he spoke before when he was interviewed, but once he's arrested and invokes his Fifth Amendment right, you cannot comment on that silence. And that's what they're doing.
Now, would it change when he agrees to testify? He's waiving his First Amendment right to some extent. That doesn't change with him on the stand?
He's waiving his right to remain silent, but he's not waiving his right from before. So, for example, during that period of time he chose to remain silent, the state is suggesting that anything he said after he invoked his right is a lie. So while he's on the witness stand, he could be challenged on his story.
Right.
So on this day, you said you weren't at the kennels, and you're saying you're admitting you were at the kennels. That's it. You can't say you're making this up now. You never told anybody about it before. That's the distinction.
Okay.
So he could be questioned about the differing stories, but he can't be questioned about not saying it earlier.
Yeah. And Waters clearly went there. So
many times.
Is it, as long as they get that in before, they hand it to the jury, is that okay? Or does it have to be made? Is it like a timely response required? What's the rule there?
So in appellate court, you have to make the objection at the time or in close proximity to the time. So the judge has given him a couple opportunities and said, do you have anything else you want to add? Are there any other, and they haven't brought it up. So that could potentially cause
They might have missed it.
Right, you've blown it. You objected, and then you acquiesced to it. So it can become problematic because if you waive the issue, you cannot raise it on appeal. He clearly raised it at one point, but then he's sort of now waiving it. So it's kind of a gray area, and it would depend on all the other factors. And some of those other factors the court might consider were if the defense asked any questions in that regard, are they acquiescing to it? It doesn't take much for an instruction to say you can't infer guilt because he was quiet until today.
Right, but did he I don't think he invoked his rights early on. He started talking to the police right away and was, doing his cooperation thing.
There's a difference. So the issue is when a person has been given their Miranda warnings, and then they invoke the right to remain silent. So if he was willing,
he was not Mirandized when he first started talking.
Correct. So if he was willing to cooperate, and then they start to say he's a suspect, he invokes the right and speaks nothing after that. Whatever is said after that, if there's a difference, he could be questioned on the difference. You said this, and now you're saying this. That's it. But you can't say you're making it up because you didn't say this. You didn't tell anybody this.
All right. Well, that's why you get the big bucks, because you catch things like this, right?
I wish.
As other than that, what do you think, especially today, of Harpootlian's performance during this rebuttal phase of the trial?
He's doing a really good job today preserving objections, which is good. Just because the judge is going to overrule it and let it in doesn't mean you stop objecting, right. Even if the judge gets upset with you, because it's not about the judge, it's about your client. So it's up to the defense to continue to object, or at least say I have an ongoing objection to all of this line of questioning, so that he's not, interrupting every 5 seconds. But he also should object when, the state makes, little comments in his questions, because he often does that. And some of those are inappropriate. Like when he turned the photo towards the jury, that should have been an objection. Yes. He just published that to
I know
the jury.
that. I saw that. I'm like, he's walking towards the jury, holding up the paper before the judge has ruled on whether it can be admitted or not. So yeah, there are little things like that. And obviously, in that case, Harpootlian couldn't see that. So he might come back tomorrow and say, Your Honor, this happened behind our back, outside of our view. This is going on because Harpootlian's between him and the jury, so he might have grounds to do that later because of he was notified it later. He might, after this break, someone might tell him, "Do you know this happened?" And he's like, "We'd like to file for the record." Okay.
I will say this before I hang up because I know it's going to start. I actually have reached out to the defense team to just send a message saying, "Hey, you guys are missing this." Yeah. So I did notice yesterday that one of the suggestions I made came up. We'll see if the other one does. And that was to continue to point to the fact that the guns in the courtroom are not the murder weapon.
Right.
So
and they brought it up a little bit today. Is this his favorite gun? When we think this is not the one that was used.
Correct.
So that was good.
And it also came up yesterday too.
Yeah. So that's awesome. Well, that's cool. I appreciate you being here with us in voice, even not on camera yet. We'll get you on camera again one time, but yeah, it'll be pretty much the same Zoom information unless we switch to StreamYard. If I can get that working, we'll probably switch to StreamYard and send you an invite that way. But thank you very much.
I appreciate it. Thank you for having me.
Yep, we'll see you in chat. Thanks, Nicole.
Okay, bye.
Okay, we appreciate Nicole coming on. She wanted to share that for quite a while, and it just didn't work out with our schedules and hers and her computer issues yesterday. But glad she was able to jump on quickly. Let's see. High Speed Drifter pointed out they aimed the gun at the lawyers. There have been so many trials where there's just if you just take a snapshot of the trial, there's something that shouldn't be important. Poot, it sounds like, is not a hunter. Like, this is not his understanding, and he doesn't have that experience with firearms that a hunter would, or a regular active shooter would. An active shooter sounds wrong. Like an active individual who participates in the sport of shooting. So those of us that have gone to hunter safety and have trained and practiced and know, whether we've taken courses in a scouting program or something else, we know that you never point a gun somewhere unless you intend to shoot it. And it should always be pointed in a safe direction, things like that. And so we immediately picked up on that. It's like he just swung the gun at the prosecutor's table. And so that shot is like, we had the same sort of shot happen in the Dean Cummings case, where Dean Cummings, at the defense's request, was handed the actual weapon, the actual firearm that was used in the shooting, in the killing, and told to reenact it using the defense as the target, basically. And so he's standing there, and even goes to the point of saying, and it happened like this, and this is how I cycled the action. And he cycles the action, which broke the band that was keeping the gun from cycling. They put a little like a zip tie through there, and cycling the action broke that, so it was now in an operable condition. And it was just one of those moments that happened a lot like this. Yeah, you shouldn't do it, but they unfortunately happen very often in court. Avid shooter. But I meant active as far as like in the hobby, like I'm actively participant. Yeah, I misspoke. Poor choice of words. If the shot was from below it and 3 feet away, a long gun would be ruled out, right? Maybe a sawed-off shotgun was used. Charlie, I wish I could find this on Twitter. There was somebody, I think their name was AZGet or something like that, that created a computer generated simulation of how these shootings may have occurred. Let's see if I can find this. Let's see, Pixie. How can I connect this?
He's texting a friend and reads his last text.
Okay, hang on one second. We're going to see if I can share this. Yeah. This is from animation by AZGet, and I have not been able to find AZGet anywhere, like their account. I don't know who it is. It was shared by Pixie on Twitter. I'm going to go ahead and retweet it for those of you that follow me on Twitter. You can see that on my timeline here. Let's see. Yeah, okay, I just retweeted it. Let's see if I can pull it up here. Hold tight. I think I got Twitter on here. I do. Okay. Give me a minute. If the judge is going to take a second, we're going to show this, a possible scenario that I wish I could give more credit to the individual who made this here. Let's see. Okay, 1 second. Okay, I guess it's from TikTok, user on TikTok, AZGet on TikTok. So let's go ahead and take this. Where's it coming in at? 7, right here. Okay, so here we go. This is AZGet on TikTok.
Paul was in a dog kennel taking a video that ended at 8:46. A few minutes later, he was walking to the feed room. He's texting a friend and reads his last text at 8:48:59. Seconds later, the first shot is fired. At 8:49:01, his phone is forever locked and never used again. Blood drips from Paul's left arm as he staggers to the door. The gunman, thinking he had killed Paul with the first shot, goes to get his other weapon, but is shocked when he senses Paul by the door. A second earlier, Maggie at 8:49 reads her last text and is interrupted by the sound of gunfire. She turns to run back. The gunman grabs his gun and runs towards Maggie. As she approaches, she sees Paul on the ground, but the gunman stops her.
This is how it accounts for the different directions.
Let's rewind this so we can see the pathologist's report.
And I'm not gonna play all of that.
Now let's circle around and see the path.
But that's one of the ways that people have been suggesting that this could have happened. Why is my Can't get my camera to come up on screen here. Wait for it. There we go. Now I'm back. All right. So yeah, that was AZ Get on TikTok, which is a great. Obviously, it's just one way. It's just one way that they say it could occur. Nobody would shoot like that. It does seem. I mean, it's not reason. Well, I wouldn't say it's not reasonable, because I've seen people shoot from just about any position. I've seen people laying on the ground shooting up in the air. I've seen some crazy stuff, but it's not common to shoot like that, especially the second shot on Paul. But this is just a scenario that could put the gun in the right position.
Come to order.
Woo. That was a good one. Quiet.
Be seated.
Someone's fixed the judge's mic for him. Should be tomorrow morning.
Bring the jury.
Tomorrow morning, I'm thinking. It's going to take an hour to get there, an hour to get back. They'll probably be there for up to an hour. So that's 3 hours. I think with 7 witnesses, if we can get them done today, we'll be tomorrow morning. If not, it'll be maybe midday tomorrow. I don't think there's any way we're going to have the jury go on a field trip today. I think Patricia, I think that little reenactment thing we just watched matches closely, or matches very plausibly with the physical evidence at the scene. That's the easiest explanation to explain where the blood and other matter was, where the pellets were, even if it puts the gunman in a strange position. It does seem weird to me to see the gunman walking around Maggie. It would be easier for me to believe that was from the same direction.
I got it right here. I'll show it to these guys first.
Yeah, that's a tough one. I think if it was a surprise response.
Doctor, I'd ask you to look at this photo and tell me if this is one of the photos from your autopsy.
Yes.
Okay, that's all I need. Thank you. Your Honor, I'd offer this defense exhibit number 195 into evidence, please.
No objection, Your Honor.
Admit it.
Okay, hold on for just 1 second.
So could we put that up on the screen, please? Before I lose it, let me hand this to. So, what are we looking at here?
Do you want me to come? Oh, here it is.
No, just tell me what it is.
Yeah, okay. So this is an entrance shotgun wound to the left shoulder area.
Okay, and you a moment ago said something about packing material. What is packing material?
Yes. So there's foam that is frequently within, between pellets.
I'm sorry, just a moment. Your Honor, I can't hear her because of the noise coming through the door. I apologize, but I just need to understand what she's saying. I apologize. May I begin?
Yes, sir.
Packing material. Let's start over again. Tell me again.
Yes. So it's frequently present in the wadding along with the pellets that sort of help keep them together.
Okay, so the wadding, you got the powder, wadding, shotgun pellets, and are these? Is it in the pellets or is it closer behind it in the wadding, or?
It's within the wadding.
Okay. And you indicated you saw some packing material.
Well, that is very consistent with, with a little bit of packing material that would, as we have pellets going into the shoulder and some of the packing materials depositing on the skin.
They're going to open up a shell and say it's actually not in this brand.
Picture of the packing material?
There is some of the white material, yes, on the skin. Correct.
Did you note that in your autopsy report?
No, it was just a general observation.
Okay. Is it important it was there?
It didn't matter to me whether it's there or not, but it does reinforce that it is an entrance wound.
But you concede it was not in your autopsy report.
Well, all the totality of my findings, I don't always write every little thing in my autopsy report. I could go on, that it could be 50 pages, an autopsy report. I include the findings, my determinations, and I could have mentioned it, but I did not.
And why not?
Because it's not always necessary to mention that kind of thing.
Is it evidence of anything?
Well, I do believe that supports an entrance wound, although I don't require myself to see it in order to make that determination.
But you agree with me, it supports your conclusion, correct?
Yes.
And you didn't put in your autopsy report.
That's correct.
Would it be in your notes?
No.
Okay. So, and could you step down here and show me what the packing material looks like? And there's a pointer right over there behind you. And you probably want to stand over here so the jurors over there can see it.
Yes. This is what I believe to be consistent with packing material.
And did you remove any of that to be analyzed or forensically examined?
No, I did not.
Okay, and while we're looking at this picture, you can actually see some shot in there, right?
Yes.
And that shot is that, that's pretty, that area right there is much wider than this entrance wound in his cheek, is it not?
Yes. This entrance wound is larger than this re-entrance wound here. And I believe I actually went over this last time. Frequently there's enlargement of wound as it goes along. But in this case, we have a wound going along the top of the shoulder, so it's going to be oblong. As it enters the left neck area, it's entering more at a right angle, perpendicular to the jaw, so it's going to appear smaller. And that has nothing to do with spreading of pellets.
Okay, well, let's pursue that a little bit more. You see that pellet that's clear, clearly there. You see,
pellet?
Right, and then you see a pellet above it. You see that? Right.
Where?
Right. Let me put my glasses on. Is that a pellet?
Yeah, it may be a pellet. Yes.
Okay. So we have, if you step back just a little bit so this juror can see, we have pellets coming in like this, correct?
Well, they're kind of banging against each other. We have the wound track is from left to right, and we do have pellets that are in there. They stopped in there, so they're not all continuing through.
Okay, how many pellets were captured in his shoulder?
I captured. I don't know how many I captured. I collected a sampling of the pellets that were along the wound path.
But you took X-rays.
Yeah, but that's not necessarily the total amount, because some of them exited and some were in the brain. So the X-rays were taken without the brain in the head because the brain came separately.
Okay, but they did send you the brain.
Yes.
Did you take X-rays of the brain?
No, I did not.
Why not?
I didn't take X-rays of the brain
and
because I
go ahead.
determined that wasn't necessary for me at the time.
To support your conclusion.
I didn't take X-rays of the brain. I guess hindsight is always 20/20. I could have taken X-rays of the brain. I could have taken more photos. I could have taken a photo of the brain at the autopsy. I did not, and I would have liked to. But you know, I can tell from the examination of the body that I had an entrance wound to my left shoulder, and it's exiting at the top of the head. It's not a contact wound to the top of the head.
Okay.
That's my determination.
Okay, but the reason you didn't take X-rays of the brain was you'd already reached your conclusion, correct? That you didn't need it because this was an entrance wound.
Well, I did not, because I felt comfortable with my determination.
And decided, therefore, not to take X-rays of the brain.
Well, I don't always take X-rays of every organ. I was comfortable I would be able to recover some pellets on the brain, and it wasn't necessary to show the spread.
How many cases have you been involved in where the brain literally exploded out of the head? I mean, that weren't suicides.
Where the brain exploded out of the head?
Well, as the book describes it.
Well, I think that the determination that an entrance wound to the top of the head, contact range, all of that gas expansion would not have, the brain would not have escaped that. There would have been a defect, a cavity, or fragmentation of the brain, which was not there. You can see the brain actually.
Do you remember what my original question was?
What was your question?
Okay, my question was, how many cases have you done an autopsy of a contact wound to the top of the head, which wasn't a suicide?
Very, very few.
Less than one?
I don't remember exactly, but it's not a tip. Usually contact shotgun wounds. Usually contact shotgun wounds are suicides.
And typically it's in the mouth?
They can be under the chin, in the mouth, sometimes they're to the side of the head. There are people that do shoot themselves to the top of the head as well. And I can't recall exactly if, I remember any of those.
And in all those cases of the brain that explode out of the cranium?
No.
Okay. So you would agree with me that the way that well, strike that. Let's go a little bit further with where we're going here. Could you put up the X-ray of the shoulder? You can go ahead and take your seat and testify from up there. Okay, tell us what this is.
Yes, they are pellets, and I have his shoulder, kind of out when I take the wound. We have some pellets remaining in the shoulder area. We have some disruption of the shoulder tissue here, some of the bone, and then we have some. We actually have less. We have more spread. They're more spread out as they're going closer to the neck.
So there are pellets in the top of the arm, the shoulder. Where is this? Right up in here?
Yes.
Okay. And then there's additional pellets, it looks like, down below that, like near his ribs, correct?
That's because it's starting to spread, yes.
And it's starting to spread to get to this place right here. Is it?
What place?
Is this where the,
No, it's in the neck.
It's in the neck. Okay.
And indicated that I recovered. It's over here. Then some of it is actually in the trachea as well. So that's the windpipe of the neck. So we have some in the neck. This is the chest area. It did not go into the chest.
Okay. Let me see another X-ray, please.
We've got some split opinions on how she's doing.
What was that exhibit? I'm sorry, I didn't announce it. 112. Okay.
I wouldn't want to be in her position. I think she's doing much better than I would do on the stand.
Okay, and where is that?
That is the top of the left shoulder and the left arm.
Okay. And you see a number of pellets there.
Yes.
That would be right in this area right here?
Yes.
Okay. Next, there's, I think, one more x-ray. Okay, and are there any pellets here? Or are those the same pellets down there at the bottom?
Yeah, well, we have, you can see, there are pellets here. We can see them in the head. There's some pellets in the head. The brain is not within the cranial cavity, but we do see some of the pellets ended up over here on the right side. See, R for right. There's the hole at the top of the head, and some of the pellets they're spread out on the right side of the head.
How many?
Well, I can see there's 3 here.
3?
On the right side of the head.
Okay.
Yes.
So if well, how many pellets are there in a 12-gauge shotgun shell, and these are used primarily for duck hunting?
I don't know. I don't know the answer to that. I'm an expert at examining human bodies and determining the injuries that occurred, and I don't know how many pellets would be. When I took my boards, I may have had to actually know that, but I don't. I don't use this information in order. You can ask your ballistics expert.
Well, we did, and I think they said something like.
Objection, Your Honor.
I don't really know the answer to that. I'm not going to disagree with the ballistics expert. I do have a trajectory an exit wound on the right side of the back of the head.
How many pellets were in the body?
I did not count them. I just collect a representative sample of it. I don't collect all of them, and I don't count all of them.
And we know you don't know how many were in the brain because you didn't X-ray the brain, correct?
That's correct.
But if there were 70 pellets or 75 pellets in his shoulder, his chest, and his neck, and hypothetically there are anywhere between 135 and 160 pellets in the normal duck shot, I mean, that's 40 pellets that travel on, for the sake of argument, correct?
Well,
my math.
I don't
use
really,
my math.
I don't feel comfortable answering these questions because it's not, the specific ballistics are not my area of expertise.
I'm not going to ask you about
I really
ballistics.
don't feel comfortable answering them. I examine human bodies and come to my determinations based on the wounds. And I can see I was correct that this is a shotgun wound to the left shoulder that's going up to the right side of the head. And questions about numbers I really don't want to I can't answer that because, I don't know everything. I'm an expert, I'm a physician, I'm an expert at examining human deceased individuals, determining cause and manner of death.
Okay, let's go back to the original question, and I assume...
I don't know the answer to the shotgun, how many pellets there would be.
We're not asking you how many pellets, but if there are 75 pellets, let's do some math here. This is simple math.
Okay, I can do math.
Okay, 75 pellets we can count in the body, the chest, the neck, and there's anywhere from 135 to 165 pellets in the normal duck shot, 12-gauge shot.
All right, so 75 plus 60, that would be 135, and then what did you say, 70? Or 80?
75.
Okay, 75. So we started with 75, plus 75 is 150. So that's your answer. If your question is, you're asking me to do the math.
So my question is this. After those pellets have gone through the shoulder and hit bone, apparently, correct?
Yes.
And then they go through the neck, do they hit more bone there?
There was some damage to the cartilage of the trachea. It was in the tracheal wall and some muscle. There's not a lot of bone in the neck. The only bone really in the neck is the spinal column.
Well, I guess what I'm saying, when you were talking about Maggie a moment ago, and you talked about a shot that I think grazed her skull, you said there was a lot of intracranial pressure. Is that right? Created a lot of intracranial pressure.
Yes.
Okay. So I'm trying to figure out, and maybe you can help me, your testimony is there was enough from the less than half the load that goes through to, I mean, was it one place it hit? Was it had to go through the brain still?
Yeah. Well, you know, I didn't say that less than half the load went through. Some of it may have actually exited the top of the head. I don't know. Or went into the brain. I did not x-ray the brain, and so I don't know exactly how many, but we can tell that this is the direction.
Was the brain macerated?
No, it was largely intact. There was some maceration at the base of the brain where it was torn from the brainstem. Okay, the brain went up and torn from the brainstem, but it was pretty much surprisingly intact, you know, from a shotgun wound.
Have you looked at the crime scene photos?
I really didn't look at the crime scene photos with any kind of, you know, attention.
Okay, so, but you are aware that the brain was catapulted out of his head, probably hit the ceiling, and then landed outside.
Well, I could tell from examining the body that the brain catapulted out of the head, because I received the brain and a hole that was consistent with the brain leaving it.
Can you and I agree, and based on your testimony when you previously testified, that there would not be, that the gas from 2 or 3 feet away would not travel through the arm, travel through the neck, and then go into the brain?
Well, there's a lot of material that's going through, and plus we've got fragments of the brain, the skull, of the base of the brain, that can also, there's a lot of energy going in that direction. Whether it's gas or not, it's energy from portions of you know, ammunition propelling in that direction. So, you know, whether you want to call it gas or whether it's other things, I really don't know the theoretical explanation. I'm sure it's in the book. But I examine the bodies and I make the determination on the direction and the type of injury from examining the human body.
The book seems to indicate that the primary cause for an explosion such as this, the brain exploding out, is the gas. You would agree?
Well, you know, I think each case is a little bit different. And the kind of gas that would cause the head to explode would also, I mean, I think the book is talking about gas, gas in a contact shotgun wound. So what is your question about the book? I would actually have to refresh my recollection, because I don't really I haven't read the book in a long time, but I know what I've seen on the body.
If I quote this to you, you would, and I can show it to you. The gas entering the closed chamber of the head expands rapidly, adding to the pressure waves acting on the bony framework of the skull. The only way for the skull to relieve the pressure produced is to shatter.
Yes.
Do you agree with that?
That actually must be describing a contact shotgun wound.
It is.
Okay, yeah, because that really makes sense for a contact shotgun wound.
And your reasoning for this, the same phenomenon to happen without the gas is?
Well, we've got injury coming from beneath. The skull is, like I told the jury, that is not shattered. We do have some horrible injury, but the shattering of the skull, much of it is still up intact. We don't have shattering of every bone. We don't have shattering of the face.
Why didn't you shave the head?
Why didn't I shave the head?
Right. Were you looking for any, if much of the skull was still there?
Look, my determination, I didn't shave the head because I was confident that that was an exit wound on the right side of the top of the head. It wasn't necessary for me to shave an exit wound.
So, but if you had shaved the head, and again, apparently you'd already come to your opinion by this point, you could have seen whether it was soot or stippling or any distortion around, or taken samples of the hair and determine whether or not there was any sort of GSR in it, which would be more consistent with a contact wound.
Well, no, GSR can just be in, we know gunshot residue can deposit in you know, I'm not, like, ballistics is not necessarily my strongest suit, but I know that GSR can deposit, you know, within a few feet. Somebody doesn't have to indicate a contact wound.
Okay, so did the shot penetrate the jawbone?
It went through the through that area. I believe it actually may have went underneath the bone.
So it did not connect with the bone, correct?
Yes.
Are any of the pellets that you see in the shoulder, the left shoulder, heading down instead of up?
Well, you know, there is probably kind of a billiard ball effect when these things are going through, and there could be some, you know, directionality. But I didn't make that determination because it wasn't important to me to make that determination.
The pellets were going?
What?
To determine which way some of the pellets were heading?
I can tell from the entirety of my finding at the autopsy. You know, the thing is, if you look at something like, you know, a postcard photograph, that doesn't necessarily tell you the whole story. I did my autopsy. I viewed all of the wounds. I was confident in the direction of this wound path. And I'm not trying to say, oh, well, which direction are the pellets going? I can see that there's the entrance wound was to the top of the left shoulder, went through the left side of the neck, and out the top of the head.
And how many pellets made it through the brain to the skull, to fracture the skull? How many pellets?
Oh, well, there were some pellets in the brain. I don't know how many.
Because you didn't X-ray it.
Correct.
So since you don't count the number of pellets, tell the jury, please, how you know how many pellets hit the skull and fractured it and allowed this eruption to occur.
I don't know how many pellets. I never said that I did.
No, I didn't say you said it. I just want to know if you know it.
I don't know the answer to that.
And it's not important to you.
It doesn't really matter. It's really very theoretical. I examined the bodies, and I made my determination based on examination of the body.
Is it true that an autopsy report should be able to be read by an independent pathologist to come to a conclusion?
Yes.
Okay. Are you ready? Okay, how about put that up for us, please?
Noises.
I'm sorry, sir?
Some strange noises. Who's talking? You're questioning the witness? Proceed.
I'm asking Doug to put up exhibit number.
I didn't hear you talking. I heard you were questioning the witness, and then a strange voice comes from.
That strange voice. Was Doug speaking?
Okay. So, how about step down here, please?
Okay, let's see.
And get the pointer for me, please. And stand over there, please, so the jury can see. So you indicated there were, I asked you if you shaved the head. You said no. You said there wasn't.
Alex is not having any of this, but I want to watch her.
Where there was enough of the skull there to determine.
If you want Alex, let me know.
Is there?
We've seen these responses quite a bit from him.
Well, I know this is an exit wound from examining the entirety of the findings, and I did not need to shave the hair. That was my opinion and determination at the time of the autopsy.
Yes, ma'am, we understand that. But what did you look at this to confirm or question your opinion, or had you already come to your opinion?
Well, I always am questioning myself during the autopsy. It's not just I look at take a long time to look at everything before I reach a conclusion. Okay, so the totality of findings here told me this was an exit wound. The brain came pretty much intact. It was propelled out of the top of the head. I believe and I'm confident that this is an exit wound, and I did not do further investigation to rule out an entrance wound because I was confident it was not.
So you just said you were confident and you did not look further because you were confident you were right.
Well, I looked at it, and in fact I took a photograph of it, and this is consistent with an exit.
It's what?
Consistent with an exit wound. brain came out of that defect. If it were a shotgun entrance wound, there would be a lot more destruction of the head.
And again, you've never seen a contact wound to the head that wasn't in a suicide case.
You know, I don't honestly remember that.
So you don't remember? Let me just rephrase. You don't remember having a case involving a contact wound to the head that wasn't a suicide case. You just don't remember it.
I may have. It's possible. I did not survey. I don't. You know. I may have seen one where somebody was shot at point blank range with a shotgun, and then the entire head is gone. So when I get that kind of, you know, if there was a contact shotgun, whether it's suicide or homicide, the entire head would have been basically blown off.
And so in every case, well, there's no reason for us to go there because you don't remember ever seeing a case where there was a contact wound and to the back of the head.
Objection asked.
I think it's honestly whether it's self-inflicted or inflicted by somebody else.
Well,
the features of the body are going to be the same. So that's my answer, and I can't, whether I remember it or not, I've done a lot of autopsies. I don't necessarily remember how many or if I've done one, but I imagine people are shot at close or contact range with a shotgun. And in a contact shotgun, whether it's by suicide or homicide, the entire head would have been basically blown apart. This is terrible, and I know it's terrible. It's probably the worst thing you ever saw, but there would be a lot more damage with a contact shotgun. And that's my professional opinion based on my experience. And if other people disagree with me, that's fine. I don't have to convince them. This is my determination based on my education and multiple years of experience doing autopsies and being a forensic pathologist.
And I think in your testimony, whenever that was, weeks ago, you conceded that reasonable pathologists can differ, correct?
Yes. I think I said, you asked me if a reasonable person, you didn't actually ask me if a reasonable pathologist, you asked me if a reasonable person could have a different opinion. And I remember that because I was sorry that I didn't say, well, of course, reasonable people can think that. But a reasonable pathologist could also think that, but I would disagree with that. Okay. I don't think all opinions, a reasonable pathologist could have an opinion like that, but I think it would really be wrong.
Okay. Go ahead and take the stand, please. Have you discussed you've met and discussed with Dr. Kenny Kinsey, about his findings?
I did meet with him once when a couple of weeks prior to the autopsy. I really never, prior to this trial, I met with the prosecution's team. And I would have been available to meet with you if you called me as well. But Ken Kinsey was responsible for the crime scene. You know, what he had to say was, I really wasn't, I had already written my autopsy report. I already came to my decision, my determinations based on my examination of the body. And whatever it was, you know, he's going to do the crime scene. So I don't remember having any specific conversation.
You don't remember talking to him about vectors and where the blood spatter would have gone? And
yeah. Well, he asked me, he said, do you know anything about this? And I said, that's your department. I really am not a blood spatter expert. So I had nothing to offer, and I really didn't encourage listening to it because it's not my area.
And let me say a couple of things. One is, you indicated that you did not put that packing material in your autopsy report, correct?
Yes.
And today's the first time you've ever said anything about packing, correct?
Yes.
Okay. Secondly, let me just sort of summarize this and see if we can get this over with. There are certain things you did not do in this autopsy because you concluded it wouldn't be helpful in reaching your conclusion, correct?
I agree with that.
Like no x-ray of the brain?
I would have been, I did not x-ray the brain, right?
Okay. There were, and your belief is that the shotgun wound to the shoulder being so much bigger is because of the angle?
Yes.
Okay. And then it narrows down to, you would concede, as a hole in his neck?
Yes.
Okay. Shotgun starts out wider. That shot starts out wider. I think we confirmed that.
The defect on the shoulder is
Right.
wider because it's kind of going across the shoulder, so it's going
Wrong
to
shoulder.
create a defect on the shoulder that's wider than something entering at a right angle or perpendicular. So that's, and I think that
gonna point
makes
out that was the wrong
sense to
shoulder.
me. It's consistent with what I've seen in more than 20 years of my practice, and there wasn't anything that seemed odd about that.
And you would concede you're not a ballistics expert?
I know the kind of ballistics. Some forensic pathologists know a lot about ballistics. I know probably an average amount.
Okay. And so when you say it started out wider and then came down to this hole, have you discussed that with any ballistics experts?
It doesn't require, that's forensic pathology. That's damage to the body. I don't need to be a ballistics expert, and I've done enough autopsies on shotgun wounds to make that determination without requiring additional ballistics knowledge.
But we can see that the shotgun starts out, the shot starts small and then the pellets expand.
Objection asked and answered, Your Honor.
Objection is sustained.
Why are there why there's no shot in his cheek if it's expanding? Why are there no pellet holes here?
Because they probably we have some wadding going in there.
Probably?
Yeah, I think that is consistent with the wadding. And there are, there's some pellets remaining in the wadding as well.
The wadding going where?
That's an entrance wound. Okay, it's entering perpendicularly. Why do we have the pellets? Did not terminate in the cheek. They continued upward.
But a number of them terminated in the shoulder.
Yes.
In the chest, up here, right?
Yes.
And then
not the chest.
Then they
the neck,
stopped.
not the chest.
I'm sorry?
Not the chest. The neck.
But the neck, the shoulder and upper neck, right?
Yes.
And then, if they stop expanding here, so the cheek isn't. One of those pellets is.
Objection asked and answered to the former question.
Your Honor.
It's been asked and answered. I sustain the objection.
Can you
doesn't know what to
say
say.
these X-rays are consistent with your opinion?
His
Yes.
face when the judge sustains an objection against him is classic. I
Beg
like
your
it.
pardon. Oh, let me ask you one question about the Maggie wound. Your position is that the tags don't indicate anything.
Well, they're not determinative. They're something we look at, but the tags on the breast are very non-specific. They're not very good tags. We happen to have nice tags on the back of the skull. Frequently, the tags are more reliable when the skin is tighter over an area.
So on Maggie, you're saying one shot's going up and the other one's going down?
Yes.
Okay. Beg the court's indulgence. Holly, anything else? Thank you. That's all I have. Thank you, Doctor.
And he's
Just
Waters can't leave
two
it alone.
questions. 5,500 autopsies, you said, correct?
Yes, and since I was here last Navy, I've done another dozen, so over 5,500.
And you rely on practical observations of actually observing the body, is that correct?
That's correct. I do my autopsies, and based on my experience and knowledge as a forensic pathologist, I know about the bodies, examining the bodies. That's what I rely on.
And your
Those are two questions. You have more?
Just a couple more, Your Honor. In your opinion, is there any way Paul's face would have remained intact if he had suffered a contact wound from the top of the head?
No.
And in your opinion, is this obviously a wound in this direction as you've described?
Objection, Your Honor. Repetitive. She's testified 5 times. That's her opinion.
Objection is sustained.
Further on.
Thank you. Nothing
Further. Thank you. You may step down.
Thank you.
Your next witness.
Your Honor, state calls T.C. Smalls.
TC. Where's TC? Is TC in the house?
Raise your right hand. Do you swear or affirm that any testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God? I affirm. You will please just sit right up there. State your full name for the record and spell your last name, please.
My name is Thomas C. Smalls. Folks call me T.C. Smalls. S-M-A-L-L-S.
Sheriff Smalls, how you doing today?
I'm doing good.
All right. Tell the jury just a little bit about yourself, and I called you sheriff, so if you just kind of explain that to them a little bit.
Okay, in law enforcement for 39 years, 8 months. I retired in December. 16 years of those 39 years was, I served as sheriff of Hampton County. Been in Hampton County all my life. I'm a pastor.
A sheriff and a pastor.
Pretty much.
That's pretty
married,
cool.
4 kids, 7 grandkids, and just trying to enjoy some retirement. I retired December 31st day of December 2022. Yeah.
Well, I'm sorry to pull you back in. You said you just retired, huh?
Yes.
All right.
2 months.
Do you know the defendant, Alec Murdaugh?
Yes, I do.
Have you known him for years?
Oh yeah.
Did you ever have a conversation with Alec Murdaugh about him asking you permission or even telling you about installing blue lights in his private vehicle?
We're going there?
No, sir. I never had a conversation with Alec Murdaugh. Matter of fact, I never had a conversation with anyone in my 39 years about installing blue lights in their personal vehicle.
That's not something that's done, is it, sir?
Oh, no, no.
Did you know anything about the defendant claiming that you permitted him to do so until he testified to that last week?
Correct. Mm-hmm.
Didn't know anything about it?
Didn't know anything about it.
And he never approached you at any point about that?
No, sir.
It's a murder trial, and we've got a rebuttal witness to say that he lied about putting lights in his car. But he did. That would be a lie on the stand if we believe that.
About any threats or anything as a result of the boat case, the boat wreck case?
No, we never have.
Thank you. Nothing further.
Cross-examination.
There's not much to cross. Enjoy your retirement.
Well, it's 12:01. Good afternoon, Sheriff Smalls.
How you doing?
My name's Jim Griffin.
Okay.
I'm a little hoarse. This pollen's getting to me, but it won't take long. You've known Alec Murdaugh for many, many years, is that correct?
Correct.
And he was a volunteer solicitor in Hampton County, 14th Circuit, for a number of years, correct?
I realized he worked along with his father.
Right.
As a, I don't know whether, I thought he was an assistant solicitor, but he worked along with his father as in Hampton County.
But he held the position of assistant solicitor 14th Circuit.
Yes, he did.
And he worked with his father,
Right.
trying cases in Hampton County and perhaps Colleton County and other places. You aware of that?
Correct. Yes, sir.
And are you aware of him trying any cases when it wasn't with his father?
Not to my knowledge.
Okay. And his father was, we're talking about Randolph Murdaugh.
Correct.
And he was previously solicitor, is that correct?
Right.
And are you aware that Alec Murdaugh was issued a badge for that position?
No, I was not.
Okay. And there's some, you were questioned about permission that, whether you gave him permission to have a blue light installed in a vehicle, and you said you did not, correct?
Correct.
Do you know whether Anthony Russell gave him permission?
I can't answer that.
Now, who's Anthony Russell?
Well, during my time when I was sheriff, Anthony Russell was a captain in my administration. He later became sheriff after I retired. He ran and he won the office of sheriff, and he holds the office now.
And he was maybe not your right-hand man, but he was pretty high up in your administration.
He was a captain.
Okay. And then Chauncey Solomon, what was his position?
Chauncey Solomon was a lieutenant.
And Perry Singleton, who's passed away, what was his position?
He was a lieutenant.
And you know that Deputy Russell, Deputy Solomon, Deputy Singleton were very close to Alec Murdaugh? Were you aware of that?
Well, I knew they knew him. I don't know how close they were.
Okay. And did Eddie Gibson install the blue lights on the vehicles for the Sheriff's Department?
Not for my cause. Most of my vehicles light was done with a company out of Orangeburg, and then later we started working with a gentleman by the name of Charles Mitchell that installed lights, and he out of, I think, Hardyville or Bluffton.
So you don't know who do you know who Eddie Gibson is?
I know who Eddie Gibson. He worked for me at one time.
And when he worked for you, did he install blue lights? He worked on the vehicles, the fleet of vehicles?
No, not my vehicles.
Well, when he worked for you, what did he do?
He was a deputy sheriff. He patrolled.
And so like you're unfamiliar that at any point in time Mr. Murdaugh had a blue light in his vehicle?
I never had any knowledge that he had blue lights in his vehicle.
Oh, thank you. That's all the questions I have.
Thank you, brother.
Your Honor, can I approach? May we approach very quickly?
See what's happening here. Everyone gets to stand up. All the mics are killed. They've approached the bench. This is one of the very few may I approach the bench moments we've had. The jury is still in the room, and that was it. So whatever it was, they came to an agreement pretty quickly. A yoga time. I'm not sure if it's yoga time quite yet. A little bit of a stretch here. I don't think the jury knows they're going on the field trip yet. It's going to be a surprise. If they're told to bring a sack lunch tomorrow, that might be the first time they hear it.
Sheriff Smalls, when did you retire again?
I retired December the 31st, 2022.
2022, so just a couple months ago.
Right.
Thank you for coming today.
Thank you, sir.
No, Your Honor.
Thank you, sir. I'll call your next witness.
Take all Paul and Randall.
Paul who? Do you see a pin? I see a lanyard, but do you see a pin?
Do you swear or affirm that any testimony you give today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You would, sir, please be seated. State your full name for the record and spell it. Last name, please.
Not sure what's going on at the Murdaugh bench.
Paul McManigal.
We'll move up here instead.
MC-MANIGAL.
All right. Good afternoon. Sergeant McManigal, correct?
Yes, sir.
All right. And you're employed with the Charleston County Sheriff's Office?
I am.
And you testified previously in this trial, correct?
Yes, I have.
Just briefly remind the jury exactly what topic you testified on earlier. Briefly, please.
I was tasked with redacting Alec Murdaugh's cell phone records to remove any possible client-attorney privileged information.
All right. And during that testimony, you were not qualified as an expert, correct?
That is correct.
All right. But you have been qualified in previous trials?
Yes, I have.
And approximately how many times have you been qualified as an expert previously in other trials?
About 10.
10 times. Okay. And is that in cell phone forensics?
Part of it was about, refer to my notes. 1, 2, 3, 4. 6 times of that was in cell phones forensics. The other was crime scene investigation.
Okay. All right. And just let's briefly go down as quick as you can. Let's go through your training experience in cell phone forensics, please.
Okay. I'm currently assigned to the United States Secret Service Cyber Fraud Task Force, which is where I received most of my training. I have been trained in basic computer evidence recovery,
the Secret Service
advanced
lanyard.
computer forensics, oxygen forensic suite training, blacklight examiner, advanced mobile device examiner, Celebrite physical and logical examination, XRY certification training, Macintosh triage and imaging, Apple iDevice forensics, Celebrite advanced JTAG extraction, network intrusion response, vehicle forensics, digital video recorder evidence and recovery, ransomware investigation response training, and several other webinars.
All right. At this time, State would seek to admit Sergeant McManigal as an expert in cell phone forensics.
So qualified.
All right. Sergeant McManigal, last week you were present when a gentleman named Micah Sturgis testified for the defense, correct?
That is correct.
And specifically, he testified about this feature in iPhone known as Wake.
Raise to Wake.
Raise to Wake, correct?
Yes, sir.
And briefly explain to the jury what that function is and what it serves as in the cell phone, for the iPhone, excuse me.
Raise to Wake is when the cell phone is laying down and you pick it up. It realizes that somebody is picking up the device and tries to assist by turning on the display so that you could possibly unlock it with your face unlock.
All right. Or read a notification, possibly, if there's a notification on the screen.
That's correct.
And so it's designed to turn on that screen when it thinks someone's picking up the phone to look at the screen, correct?
That is correct.
All right. There's been previous testimony, I think, by Mr. Sturgis and other experts in this case that the iPhone, if the screen is off, it will not record an orientation change, correct?
If the screen is off, it will not record an orientation.
You agree with that opinion?
I agree, yes.
Okay. And you were asked after Mr. Sturgis' testimony to investigate a little bit more about this raise to wake feature, correct?
I was.
And specifically, as demonstrated with the jurors, the screen is going to turn on when the phone is picked up gently, correct?
That is correct.
Because the phone thinks it's being picked up to be looked at, correct?
That is correct.
You're asked to investigate with a test device whether that screen lights up every time a phone is picked up in a more violent fashion or quicker fashion, correct?
On my test on my desk,
when the phone is
it does
picked up
not
more
light up
aggressively or moved more aggressively, the device will not turn on the screen.
And that's because the way raise to wake feature is based off of what in the cell phone? What's telling it to wake up?
The accelerometer primarily.
Okay. And so the accelerometer is sensing motion, correct?
Correct.
And so if it senses a slight amount of motion, it's going to turn the screen on because it thinks someone's picking up to look at it, correct?
Can't lead the witness.
And so if the cell phone only detects a slight amount of motion, what does it do? What does the iPhone do?
So if the iPhone registers a slight amount of motion, it thinks it's being picked up, so it will turn on the screen. But if it's being picked up more aggressively, it won't. And that's a battery protection feature. If you had the iPhone in your pocket and you were jogging, you don't want the screen to stay on the whole time. So when the phone is moving more aggressively, the screen does not turn on.
Okay. And so you're asked to do some tests in your lab with a test device, correct?
That is correct. I obtained an iPhone 11 Pro Max, which is the same make and model as the phone that Maggie had.
All right. And what software version was on your test device?
The software that was on my device is iOS 14.8. The one that was on Maggie's was iOS 14.6. So the iOS that was on my device that I tested was slightly newer.
Okay. And did you perform a series of tests with various motions and various throws with this phone to determine, and were you able to develop an opinion of when the screen might come on and when it might not?
Objection, Your Honor. Basis for the objection.
Rule 5, this is an experiment performed on evidence, section something C, and we have not been provided this.
Objection is overruled. Rule 5 does not apply.
Thank you. So you did perform a number of tests, correct?
Yes, sir. Performed many tests over the weekend. I pick it up and shake it, pick it up and throw it. I threw it off to my desk. I knocked it off of my desk. I tried to flip it end over end. I tried to throw it like a Frisbee. I did each one at least 10 to 20 times.
Okay. And were the results 100% conclusively? I mean, did the phone do the same thing every time?
No, not at all. Sometimes the screen would turn on. When I threw it, land face up, and then the screen would turn on. But a lot of the times I would throw it, and the screen would not turn on. It depends on how the accelerometer registered that movement.
So based off your test, is it your opinion that
over the weekend
an iPhone of the same make and model as Maggie's could be thrown and the screen not turned on?
Can't lead the witness.
All right. Did you develop an opinion about whether the screen would turn on every time a phone was thrown?
If the phone is thrown, the screen does not always turn on. In my experimentation, I determined that when the phone is thrown more like a Frisbee, 9 out of 10 times, the screen does not turn on. The times that it did turn on most often was when I pick it up and tried to shake it, then the screen would come on briefly.
Okay. But 9 out of 10 times, when you toss a phone like a Frisbee, the screen would not turn on, correct?
That is correct.
Nothing further from the state.
He's certified as a phone throwing expert. He's tried it hundreds of times over the weekend. Plus, he watched a webinar. The sample phone isn't Maggie's phone. That's an issue.
When you performed these experiments, did you record them in any way?
I did not.
You didn't video record doing any of this?
I did not.
Did you consider video recording any of these experiments?
Actually, it never crossed my mind.
You just did the experiments and then just sort of orally relay when you could have had a video to show us?
That is correct.
If you were going to throw a phone out from a moving vehicle, wouldn't you need to pick it up, to toss it?
Certainly.
And if I understand the previous testimony, when you pick it up, the screen comes on.
When you pick it up gently.
So if you pick it up to toss it out the window while you're driving, you got to pick it up. Is that correct?
Correct. And if you pick it up aggressively, it will not.
But not always.
Not always.
Sometimes will, sometimes won't.
Correct.
According to the experiments that you conducted since
when did you do over the weekend?
I started it Friday afternoon and into Saturday.
So you did these experiments this last weekend?
Correct.
You did not record any data?
I did not.
You just played with the phone and are coming here to express your observations?
That's correct.
As an expert, that you
do you
did not
have the
object
phone
to.
that you used to do these experiments with you?
Not with me.
Are you aware of how the phone in this, Maggie's phone in this case, how it, when it was located, what its position was? Have you seen the photos?
I have.
And was it screen up?
It was screen up.
Okay. Would you agree then that it had to be thrown from a screen up position, because if it was screened down and you turned it over to throw it out, the screen would come on?
Of course not. It can tumble through the air.
So if the phone was screen down in the car and it ends up screen up over here, it has to turn over, right?
At least one time, yes, sir.
And Do you, I guess, disagree with the previous testimony and demonstration that when you take the phone and turn it over, the screen comes on?
No, when you pick it up gently, the screen does come on.
We say pick it up. If you rotate it on that axis so that it's screen down to screen up, does the screen come on?
If I pick it up gently and rotate it, the screen comes on. If I pick it up aggressively, it does not.
And if it's facing you and rotates 90 degrees, does the screen come on?
Only if you do it gently. Again, if you do it aggressively,
How
it will
gently?
not.
Did you measure any of these forces?
I did not.
You just threw the phone around in your office?
Absolutely.
So you didn't record what you were doing, and you did not measure any data. Was this because you were afraid that you would have to disclose that data if you recorded it?
Of course not, no.
Do you normally do experiments and don't record any data or video, record anything?
It never crossed my mind to record video.
Do you believe that you would have to have disclosed that data if you had recorded it?
Objection, Your Honor.
Overruled.
I believe so, yes.
So the reason you didn't record data was that it would have to be produced, and then we could examine it and discover whether or not it was accurate.
No,
you
sir.
avoided that by not recording anything, correct?
No, sir. That's not correct.
Why didn't you record any data?
It did not cross my mind to video record my experiments. I just did the experiments to determine whether or not
And
the screen would
you
turn
didn't
on.
occur to you to measure how fast you were moving the phone? Maybe to even find out what is that threshold you claim where the phone goes from turning on to not turning on? Exactly when does that happen? You have no idea, do you?
No, sir. It would take me much longer to do these experiments to determine the exact speed and force required to turn the display on versus not.
Did you discover any, or did you attempt to locate any documentation regarding the raise to wake feature on the iPhone?
I did. I tried extensively. I reached out to several different forensic surface focus groups that I'm a part of, and we were not able to find any white papers on the subject.
So you were unable to find any actual data on it, so you resorted to throwing your phone around alone? Was anyone with you when you did this?
No, sir. I was alone in my office.
So you're alone in your office, throwing the phone around, taking no measurements, recording nothing over the weekend, and then you come in here and testify as an expert as to what the phone will do.
That's correct.
And testify that it's different than what we've seen it do right here in this courtroom.
That's correct.
Have you ever done this, anything like this before? You'd mentioned testifying 6 times before. Was this your expert testimony in any other case?
My expert testimony in other cases was always about cell phone reports and the data contained therein. I've never actually done physical experimentation to come up with a realistic result.
So your previous experience was extracting data from cell phones, is that accurate?
Correct.
Is that what you're trained to do?
Yes, sir.
The training that was listed, it was to extract data from a cell phone?
Yes, sir.
Are you an engineer?
No, sir.
Do you have any certification in engineering?
No, sir.
Do you have any degree, academic qualifications in engineering?
No, sir.
Have you ever worked as an engineer?
No, sir.
You're trained in extracting data from the cell phone?
That's correct.
And when it comes to tossing it around and seeing how it moves, you don't know anything more than anyone else, do you?
No, sir.
So you had this...
You should have objected.
Your Honor,
you should have objected.
Based on the previous answer, I would move to strike the expert opinion.
On what basis?
The witness just testified he has no expertise in this. That he just said he has no more knowledge about this than anyone else in the
Are they going to win this one?
That his expertise is in extracting data from the cell phone. And that this opinion is therefore outside of his expertise, and this is inadmissible opinion testimony.
Previously stipulated that he's an expert.
Yes, Your Honor, in extracting data from the cell phone, which was before we got to this testimony about
Says the state.
Your Honor, this witness performed a series of tests. He's reporting on. I'm sorry, Your Honor.
We know that. He's testified to that.
And he's expressed his opinion of what the phone will do in those series of tests. It's not an absolute opinion, but I think he can. His opinion of when the screen would light up is something he's put.
Anything further?
Your Honor, simply that when he was proffered as an expert before this testimony, it was in extracting data from the cell phone, not in
I think defense might win this one.
Electrical engineering, which is where he's gone now.
Objections overruled.
Oh. That was good cross.
So you just testified you have no more knowledge
The jury
about
got to hear that too, though.
engineering the iPhone than anyone here, correct?
I know more about how the iPhone works, but no, sir, I'm not an engineer.
You're not an engineer. When you said that the accelerometers are what trigger this feature, how do you know that?
That's from data that's on Apple's website.
So you found something on Raise the Wake that says that the accelerometers are what trigger this feature?
No, sir. That's the only thing that is capable of detecting motion on the phone, besides GPS.
Good answer. There are devices
And you have
that will
no
show
idea
you
how much
exactly
motion
what
is
forces.
required because you didn't measure, correct?
No, sir. I don't know the threshold.
Okay. You, this weekend, sat around your office by yourself, recording nothing, tossing the phone around here, and are now reporting those results as an expert in what?
In cell phone forensics. I understand how cell phones operate more than most people.
Do you understand the electrical engineering? Do you have any background in that?
I am not an engineer, no, sir.
Do you know how the accelerometers in the iPhone work? Can you tell us?
Not exactly, no, sir. But I know that they exist, and I know that's how the iPhone determines motion.
So there's an unknown device within the phone that detects motion in a way that you don't understand, and some amount of motion that you don't know how much because you didn't measure it does something that only you saw in your office this weekend. Is that correct?
No, I know what that is. It's the accelerometer. The accelerometer is what detects the motion, and that's what causes the iPhone to race to wake.
How does an accelerometer detect motion?
I'm not an engineer. I do not know how it detects motion. I just know that it does.
But, sir, you really haven't said anything you couldn't quickly find out on Google. Isn't that correct?
That's correct.
Probably, yes, sir.
So you have no expertise in this.
I have expertise in how cell phones work.
What do you mean by that, how cell phones work?
So I can tell you all about the knowledge C databases. I can tell you about the way iPhones, or not iPhones, I can tell you the way some software is written, what kind of code it's written in. I can tell you how data is stored on the cell phone, the programming that's involved with the iOS feature, and the different databases that are involved.
Can you tell us that if somebody was driving down the road, picked up a phone that was either on the seat or pulled it out of a pocket or something like that, and while continuing to drive, threw it out the window, that the screen would not come on if it landed face up?
I cannot tell you that it will not come on. I can tell you that it might not come on.
Because when you were alone throwing your phone around, you think it didn't come on sometimes.
Objection sustained.
No further questions.
Anything further?
Just real quick. When Mr. Barber was asking about picking up a phone and then tossing it, about the raise awake, what Mr. Sturgis demonstrated jury was a gentle pickup, correct?
That is correct.
You test a more violent pickup or a more aggressive pickup and then moving to a throwing motion, correct?
Yes, sir. I just picked it up and threw it.
All right. And based off of what you tested and you observed, the screen does not come on most of the time?
When you throw it like a frisbee, it's most of the time. When you throw it end over end, it's more than half the time it will not come on.
All right. And Mr. Barber asked you several times whether you knew more than anybody else about these cell phones, correct?
Correct.
And in particular, in this instance, you do know more than most people because you performed a series of tests, correct?
Objection sustained.
You performed multiple tests over the weekend, correct?
That's correct.
Objection sustained.
What did you do this weekend?
This weekend I performed multiple tests on a
Oh.
device matching the same make and model as Maggie Murdaugh's to determine whether or not the raise to wake feature would always enable the screen to come on whenever the phone is thrown.
All right. And Mr. Barber asked you several times about being an engineer, correct?
Correct.
And did you hear anything out of Mr. Sturgis last week that indicated he was an engineer?
No, sir.
All right. And do you testified you don't know exactly how the accelerometer works, correct?
That is correct.
Is that knowledge necessary to observe when a screen turns on and when it does not turn on?
No, sir.
Not further.
Anything further?
Please. He doesn't have the phone. Doesn't have the right phone to demonstrate. This is so good.
One question. How many times do you have to run this experiment for your results to be statistically reliable?
I'm sorry, say it again?
How many times do you need to run this experiment for your results to be statistically reliable?
I'm not a statistician.
More than 10?
What your basis for that is?
It doesn't take that long to figure out that sometimes it turns on and sometimes it doesn't.
Do you know how to measure reliability using statistics?
I took statistics in college, yes, sir.
Do you know how to measure reliability using statistics?
Yes, sir.
How do you do it?
Well, you have to have a performative sample. You have to have a default group that has no change to it, and then you have to have your sample group where you actually perform a change. You take the data, you put it into a formula, it gives you a degree of reliability.
Did you do that here?
No, sir.
No further questions.
Step down. Call your next witness.
Your Honor, state calls Mark Ball.
I don't know who the guy in the green and black striped shirt is. Very bright colored shirt. Looks like he's got the ZZ Top beard going on. Haven't seen him on the family side before, so I'm not sure who he is. Does anybody know who that is? Other right.
Do you swear or affirm that any testimony you give today will be the truth, the whole truth, and nothing but the truth to help you God? I do. All right. Mr. Mark, thank you. You'll be seated and state your full name for the record. Your last name, please, sir.
Welcome, Diego.
It's Mark Ball. Last name B-A-L-L.
How you doing?
Mark. Mark's back.
Be doing better if I wasn't here.
I hear you.
He did.
Well, we'll get you out of here pretty quickly. I wanted to just ask you a few very quick questions in response to the defense case. And first question I'd ask you is, prior to the murders of Maggie and Paul, did you ever hear Alec express any distrust of SLED?
No, sir.
Can you tell the jury what your observations were of his relationship with the law enforcement community?
I thought it was very good. I mean, he interacted with them regularly, as most civil lawyers do, and then with his side gig as, solicitor, he obviously had interaction with them as well.
Thank you, Charlie.
Do you remember...
Congratulations, Natural Empress.
Coming to find out that Alec had installed blue lights in the private vehicle?
Yes.
And can you tell the jury roughly how long ago that was?
I can't tell you precisely. I can tell you it wasn't the vehicle that's been seized. He got that vehicle in the end of December before the murders occurred in June, so he'd had that vehicle about 6 months roughly, and it was on the vehicle that was prior to that, and it was a Suburban as well. I don't remember when in that chain that they were actually installed, but it was some time.
Do you have some property around in this area?
I do.
And are you a hunter and an outdoorsman and shooter?
I am.
All right. Do you ever shoot hogs and other nuisance creatures?
A bunch of them.
You'd never know, but this is a murder trial.
What can you do that in the daytime?
Yes.
And is it not uncommon to see hogs during the daytime?
I shot 2 weeks ago. I shot 5.
During the daytime?
During the day, 4:30.
That's daytime. Just checked.
They come out, all different times, and the more pressure you put on them, the more nocturnal they'll become. But they eat all the time, and they root, and the rooting's what the real problem is. They root up your roads and fields and everything else.
Have you ever known the defendant? You've known the defendant for how long?
34 years.
You aware the defendant and his family had a number of long guns, rifles, and shotguns?
Yes.
Have you ever known him to talk much about target shooting a pistol?
No, sir.
You know what Paul's weapon of choice was when shooting hogs?
Shooting
hogs.
The 300 blackouts were bought for hog hunting. I assume Paul would have shot him with anything he had, but that's what the 300 blackouts were bought for.
Did you have any conversations with the defendant when he was purchasing the original 2 blackouts as it relates to hog hunting?
I did. I'm not a big 300 blackout fan, and I told him that, and he bought them anyway, and I think his cousin actually put them together, who was a game warden.
In the time after the murders, did you have a number of conversations with the defendant about his activities that night?
I did. I had that night and then subsequent days.
And did you go over those in fairly some sort of detail?
Yes, sir. At times, sometimes it wasn't detailed. It would just be checking on him to see how he was doing and to see, if they'd come up with any leads or where things stood. I mean, everybody was trying to figure this out. I mean, this is one of those lightning strikes in life that just jolts you and there's no rhyme or reason.
What, if anything, did he say about whether or not he checked Maggie and Paul before he called 911?
As I testified before, my recollection of it was that he testified, or he told me, not testified, but he told me that he went to Maggie and then he went to Paul, rolled Paul over. His phone, I didn't hear the phone the first time he said that. I think that was about the second or third time. But I also wasn't really listening. I was listening to what occurred. Who did this? Why would they have done this? But the second time he went, it was reversed, where he went to Paul and then to Maggie. And like I told you before, I don't know whether that's just a slip, from one to the other or vice versa. But he definitely went, checked on him, then called 911.
When was the first time you heard his admission and claim now that he did go to the kennels around 8:44 p.m.?
Thursday.
Last Thursday?
Yeah.
And was he clear prior to that he did not go down there in his conversations with you?
Never said anything about that or any reason for it. It just, he'd never been there.
You guys are cracking me up today.
You said you've known the defendant for how long?
34 years.
Knowing what you know now, was he able to look you in the eye and lie convincingly and effortlessly to you?
Objection.
What's the objection?
The objection's overruled.
I mean, it's pretty obvious. I didn't know the stealing. I didn't know any of that. And, it's not the way a plaintiff's practice works. You work on your own cases unless you're working with somebody else. And so you wouldn't necessarily be talking about his particular cases. So it's sort of yes and no. I mean, obviously, a lot of things that I was told and a lot of things just weren't there. I mean, the blue lights, the reasoning for the blue lights, the money missing from our account when he cashed the 2 checks, all of those types of things. Obviously they weren't truthful.
And did you feel like you knew the defendant well prior to June?
Sure thought I did.
Right of defense.
Good afternoon, Mr. Wall.
Good afternoon.
Just be clear, after the Labor Day weekend when Alex was confronted by the law firm.
Well, it was before Labor Day.
Yeah,
it was Thursday.
Friday or Thursday
Right.
before?
It was the Friday before we confronted him.
You ever talked to him since the day he was confronted?
I talked to him on that Monday when I believe that he and Randy and John were going to, I believe, Atlanta, to the facility down there. And I got a phone call, I don't know, 1 or 2 o'clock, whatever it was. I was coming from the office. I'd been digging through his files and stuff, and I got a call. It registered as John Marvin, and I picked it up and said, "What you need, John?" And it was Alec.
And that would have been Labor Day 2021?
That would have been Labor Day 2021.
And since Labor Day 2021, you've not spoken with Alec?
I have not.
And since Labor Day 2021, Alec has either been in rehab or jail, is that correct?
He has been, to my knowledge. I mean,
so you've not had any opportunity. I mean, he's been represented by counsel as well, right?
How many days is that? Is that how long he's been sober as well?
You know, he's being charged with crimes.
Right. So you wouldn't have any expectation that since September of 2021 that he would come to you, talk to you about whether he was on a video, whether he was at the kennels, or where he was, correct?
No, not since September.
Okay. You were asked questions about Alec's distrust of SLED, and you testified that he had a good relationship with law enforcement.
He did. I never heard any mistrust of SLED or anybody else.
Well, let's talk about that.
From him, I mean.
Well, did Alec take the position that his son Paul was wrongfully charged for felony boating under the influence causing a death and serious bodily injury as a result of the boating accident?
Yes, I mean, I think he disputed that and was planning a vigorous defense of that.
And that happened, those charges have been pending since 2019, is that correct?
4 years ago, a couple of days ago.
Right. And so he did express some dissatisfaction over that case, correct?
Well, over that case, but I don't know that it was directed at law enforcement or who it was directed at. It was just, it wasn't, he didn't specifically say or didn't say, I distrust SLED or I distrust Beaufort County Sheriff's Department or DNR or whoever. It was just, he thought that there was defensible, it was a defensible case, the criminal charges against Paul, and you know, there was this back and forth as to whether it could have been one of two people driving.
And you were informed, I believe, sometime in the spring of 2021 that SLED was actually investigating Alec for obstructing the boating accident investigation, right?
No, sir.
You were not aware of that?
I was not aware of that.
Do you know whether Alec was aware of that?
I have no idea what he was. He never said that to me. I didn't know about anything to do with the investigation until the grand jury, when I went to the grand jury.
Were you aware that he and his father sat in on the criminal prosecution of his good friend Greg Alexander?
I became aware of that. Well, back up. Yeah, I knew they went over there. I didn't know much about the detail until after the SLED came in after the 3rd of September 2021.
And Chief Alexander was prosecuted after SLED investigated him, correct?
I think that's the case, yes.
Yeah. And that Alec and his father thought that Chief Alexander was wrongfully accused. Are you aware of that?
I don't know what they thought about it. I know that they were close to Greg Alexander, and Greg Alexander ultimately got off on a jury trial.
Now we do know that the Colleton County Sheriff's Department, in this case, recused themselves because Alec was...
Let me correct something. I said that he got off. He was found not guilty.
Right.
I mean, I don't want there to be a negative implication. I know Greg as well.
Sure.
So...
Well, thank you for clarifying that. And we do know that Sheriff Buddy Hill and the entire Colleton County Sheriff's Department recused themselves in this case because of Alec's close relationship with the Colleton County Sheriff's Department and law enforcement. Is that right?
I know they recused themselves, and I know they called in SLED that night. I wasn't privy to the reasoning,
Right.
but I would make that assumption.
And there are different levels of law enforcement agencies, right? There's the, say, the Town of Hampton Police Department, Hampton County Sheriff's Department, and Alec had a really good relationship at that level with those folks, correct?
He did.
And he had a really good relationship with the Colleton County Sheriff's Department, to your knowledge?
Yes.
Right.
Sorry about that.
But I think I covered that. So you mentioned that hogs become nocturnal when there's a lot of pressure on them?
They can.
They can?
It depends on a lot of things. Like right now, the swamp's up. They're much
Swamp's
more on
up.
the hill.
Right.
Then
Time for
when
hog hunting.
Times are dry, they go out into the flat swamp and root up everything out there.
And the pressure that you're referring to is hunting pressure.
Yeah.
And are you aware that Paul put a lot of pressure on the hogs at Moselle?
I knew Paul hunted hogs a lot of places. At one point, Paul had hog dogs and would hunt on people's property. He came to my property. He went to Ronnie's. But how much pressure they were putting on them, I don't know because I wasn't over there. I mean, I'd ridden around their property several times, but it wasn't about hog hunting.
Sure. And I want to ask you about the Moselle property track. So, we've all seen drone photos of the house and the kennels and Moselle Road. That's sort of right in front of the residence.
Yes.
Very. And then if you're sort of looking from a drone, and we've seen some aerial photos, I guess if you're headed south, there's the Dove Field right adjacent. Is that south, I would think?
Yeah, at least east.
Okay. And then back behind the Moselle residence, I think there's a river.
Well, there's a swamp.
The swamp
and
again.
then the big Salcahatchee is back in there.
So the swamp begins behind the house and goes, I don't know, is that west?
Sort of south.
Right.
If the runway's running east and west,
okay,
then it would be south.
But the swamp is behind the house.
It's behind the house.
Okay. And across the street from the house is duck pond and shooting range and no swamp.
Correct. And timberland.
And all the hogs are going to be behind the house.
Mm-hmm. They're all over. They follow. There's a watershed ditch in there. They follow wherever, but predominantly they seek refuge or whatnot in the swamp. But they can be anywhere. I have them. There's gum ponds and every place else, and they just trample wherever they want to go. But you're right. By and large, they're in the swamp because it's wooded.
Right.
And thick.
And in the month of June, pretty warm, is it not?
It usually is here in South Carolina.
Yes, it is. And do hogs stay in the swamp more in the heat of the summer?
I haven't noticed that, and I've killed probably well over 1,000 hogs.
All right.
He's a mass hog murderer.
We trap them all the way through. I mean,
Trapping's
got 2
different.
traps, and well, actually, I got 6 traps. But I mean, I trap. You trap them, I shoot them.
Trapping, they're very active at night.
They're just a scourge.
You shoot them in the trap during the day.
They root up your roads. They get in your pine trees when they're little. They'll root them up.
They'll trap them and shoot them in the
They're
trap.
a teetotal nuisance. I carry a gun with me most of the time.
But not a 300 block.
Do you have a gun with a thermal scope so you can hunt them at night?
I do have a thermal, and then I have others.
Yeah, Mr. Small, is there ever a time when you don't have a gun with you when you're traveling around?
Only if I forget it.
Right.
But
that's what I thought.
Usually I have one.
Oh, yuck. DMB, don't go there.
And you understood that Maggie and Alec got 300 blackouts from Paul and Buster for Christmas one year, and they came with thermal scopes.
I do.
And are you aware that Paul had his lost or stolen?
I was.
And then he received a replacement without a thermal scope.
Right. My understanding was it had a red dot.
And that he didn't use that one very often. He used Buster's that did have the thermal scope. You've learned that?
I've heard bits and pieces. I haven't been watching everything, but I did.
Right.
Somebody told me that, or I heard it, one or the other.
And Buster's was sitting here in the courtroom. Were you aware of that?
I didn't. I assumed y'all had.
Okay.
I know that the black one was taken from the house because I was standing there.
Right. That's fair.
But you wouldn't use a thermal
in the daytime.
In the daytime, for the most part. I mean, you could, I suppose, but it wouldn't serve much purpose.
Ease up, everybody. Let's let them fight in the courtroom. We're going to have a good time here in chat.
Alex, emoting and being emotional during trials. He's an emotional person altogether, isn't he?
I think he probably is.
I mean, you remember him speaking at when his dad got the order of the Palmetto, for example.
I do.
And he'd get emotional then.
Yeah.
And you remember him speaking at the trial lawyers after he had finished up his term, and he got emotional then.
Well, I wasn't there for that. So.
Oh, you missed that? Okay. But you've seen him get emotional frequently.
Sure, everybody gets emotional.
Right. And he was extremely emotional after losing Maggie and Paul.
There's no question about that.
One last point. Do you recall reading or learning on the morning of June the 8th that statement was released through the Colleton County Sheriff's Office that says, at this time, there's no danger to the public. If information is received that dictates otherwise, we will immediately notify the public?
Yes.
Did that concern you?
Very much.
And why did it concern you?
Well, I had been over there that night. I left 3, 4 o'clock in the morning, came home, laid down for a little while, took a shower, and then I heard that. And I got on the phone with Sheriff Smalls on my way into work about 7:30 or so, and I asked him if he knew anything about what that was about, and he said, I don't know, I'll check. And then later that evening, the lieutenant from over here called me, and he explained that they didn't have any credible threats against anybody other than, they didn't have any threats, period, but they didn't have any, there was no knowledge, no information about anybody else being in harm's way. And we had probably a 30 or 45-minute conversation, and it didn't leave me any more. I guess I still had questions because we have 60 or 70 people that work for us. Sure. And the last thing I wanted was somebody coming in and blasting up the place. And so we made the decision to lock the doors, and we did that for probably a couple months.
Right.
And just like we're doing now.
Thank you. Indulgence. That's all I have.
Further.
You were asked a little bit about Colleton Sheriff's Department recusing themselves. Are you aware that they continue to assist on the case?
I know they were out there, and I wouldn't, the internal politics of who's lead and who's not lead. I mean, I know that they were there because one of the deputies called me the next morning and asked me where Paul's truck was, and I called Alec and verified where it was, and I had several interactions with them. So yeah, they were still involved. They weren't.
And for the first few months of the investigation, the local solicitor's office was still running the investigation, to your knowledge?
As far as I know, they were out there. Mr. Stone, his chief assistant were out there, and an investigator were out there the next day. And I want to say they were out there maybe 2 days, but to lend whatever assistance they could lend, I guess.
And that'd be the same
and
solicitors?
then I think it was August. I saw it like everybody else in the paper that Mr. Stone had recused himself.
And that'd be the same office for which the defendant had a badge, is that correct?
Correct. He was an assistant, and so was his father.
All right. Thank you. Nothing further.
All right, we're moving right along. Oh, man. I thought we were moving right along.
Isn't it correct that law enforcement does the investigation, solicitor's office does the prosecution?
That's the way it normally works.
Thank you. That's all I have.
Thank you, Your Honor.
All right, finally. How many witnesses have we had so far? The state says they have 7. I spoke too soon.
We're going to break, excuse the jury now, till 2:15. Please do not discuss the case.
2:15. That means we have till 2, or we're going to come back at 2. We come back 15 minutes early, and we're going to hear that. Let's see if they have any business to discuss here in court before anything happens. Suzanne just gifted 5 memberships. Thank you very much, Suzanne. Let's see who the lucky winners are. It looks like Bill Brasky, Natalie Lintz, my dog Murray, girl in Texas, and Jody Estes. Congratulations. Thank you, Suzanne, for your generous donation, and congratulations to the new members. Please take your seats.
So everyone be seated.
Let's see what's up. I think we're going to hear
How many
about
more
the field
witnesses
trip.
do you have, Mr. Waters?
I believe just one, Your Honor. Lunchtime, there's one more that I might talk about, but I believe just one, Your Honor. And that would be Dr. Kinsey.
Dr. Kinsey. He's trying to figure out what to do with the field trip. You can see the judge has his iPhone on his desk. He's probably been playing flip
I've
phone.
received an email that I want to have counsel look at. Let's see trying to figure who works here.
Trying to figure who works here. There's audio people and stuff that aren't part of the courtroom that are sitting up there to run the audio. So counsel gets a copy of this email. They're going to review it, and everybody wants to read it. Everyone's headed up to the well. It doesn't matter if you've never even questioned somebody in this trial. You want to read this email right now. He's presented it to the jury because it concerns the court. Come on, please give us the audio back.
About it on the other side of lunch.
Says, get up. Go back to your benches, please. Lawyers, back. I wasn't going to say like flies on a carcass, but it did look like they got up there pretty quick. Please share with the class.
Anything else before we break for lunch?
Your Honor, very briefly, I know that there had been a request by the defense for a
field trip
jury view, and for planning purposes, I didn't know if Your Honor had if we had some plan for that, to do that, I guess, after this last witness, or at what point?
Yes, after the state rests.
All right.
And depending on what time you rest today, it might be this afternoon.
Sheriff's Department better be on their game.
Yes, sir.
And be ready to make that happen.
Now or after lunch, whatever the court prefers, but I would like to make a counsel motion for the record regarding the cell phone testimony we just heard.
Okay.
Let's hear it.
Your Honor, and the previous objection was that it was which overruled. I was objecting to it being beyond the scope of the expertise with which it was offered, but the Supreme Court and counsel...
That wasn't your objection.
That was the objection. I'm now making a motion under counsel, Your for the record. In counsel, the Supreme Court said that when admitting scientific evidence, the trial judge must find the evidence will assist the trial fact, the expert witness is qualified, and the underlying science is reliable. The trial judge should apply the Jones factors to determine reliability, and then the case gives the Jones factors as considering the admissibility of scientific evidence under the Jones standard. The court looks at several factors, including one, publications and peer review of the technique.
You know what the rule says beyond that?
Your Honor, the testimony we heard, which we had no notice of to make an earlier motion, there's no publications or peer review of the technique he described. There's no prior application of that method. He testified he's never done this before. Number 3, the quality control procedures used to ensure reliability. No data was recorded at all, so there's none of that.
Your motion is late. You stipulated, you agreed that he was an expert. I gave you an opportunity to voir dire him, question him in any way.
Your Honor, we had no notice that he was going to offer this.
I'm with the defense on this one.
He was offered as a cell phone forensics expert, which he is. And there was no notice that he had done this engineering analysis throwing his phone around.
He did not do an engineering analysis. He said he didn't do an engineering analysis. And what was scientific about his testimony?
Well, yes, Your Honor, his testimony was not scientific. That's why moving under counsel that it is not reliable scientific testimony and should be struck.
All right. What says the state?
Your Honor, I think, again, as Your Honor's pointed out, there was no objection. This was in the nature of reply testimony, and I think that, again, there's a practical experience that is acceptable for opinions to be offered, and that's kind of what we're talking about. He understands the raise-to-wake feature and the manner in which it works and in which it doesn't work, and he offered his testimony based on his experiments in that regard. Counsel was allowed to fully cross-examine the witness, and it will ultimately, go to weight and not admissibility, Your Honor.
All right. The objections are noted for the record. He did not provide scientific testimony. He conducted an experiment and told the jury about it. The fact that the defense had any questions concerning his qualifications to testify as an expert witness, the defense had an opportunity to do that through voir dire or otherwise. Rule 5 does not apply to reply testimony in the sense that the state is not required to provide any advance report or anything. Your objection is noted for the record. The testimony speaks for itself, and that's that. Yes, sir.
Your Honor, one other matter. The forensic pathologist said this morning concerning some of her testimony about the white material that was noted. She indicated that she had never put that in her autopsy report. She'd never given this opinion before. We propose in rebuttal to bring our pathologist back to testify when they finish their case.
I'm not inclined to allow any rebuttal based on what I've heard at this point.
Even though she said wasn't in a report,
yes, sir.
Revealed it today for the first time.
Yes, sir.
Thank you, Your Honor. So you're denying that request?
Yes, I'm not inclined to at this time.
Well, when would be the appropriate time?
Well, when it's time for you to offer it, then I'll hear it fully. But I'm telling you now, I do not anticipate allowing any rebuttal based on what I've heard at this point.
Thank you, Your Honor.
Yes, sir. Anything else?
Nothing from the state prior to the lunch break, Your Honor.
Nothing from the defense, Your Honor.
Can we talk about the email, please?
All right, we'll be in recess till 2:15.
All rise. Okay, so it's lunchtime apparently. We're out of there till lunch. So we get 1 hour for lunch. That's long enough for everybody. I'm going to try to watch Twitter. That's probably, if somebody heard what was being discussed when the lawyers were up at the bench, Twitter would probably be where it's at. So I'm just seeing here. I really love. I love this take on. Hang on 1 second here. Lawn Lumber has a great take on this, saying this is frustrating to watch. In all sincerity, the prosecution's case was stronger before the decision to bring witnesses in rebuttal. They have sort of flopped on several of them, I think. Could have done better just leaving it be. This was a chip shot for the judge. Not a good look for equal application. Who is Sarah Boone? Natural Empress. You will know who Sarah Boone is soon enough. Don't go anywhere. Don't go anywhere. Email was from Sarah Boone. I'd like to contact you about my case. Where's my case? Where's my lawyer? Passing shots around there, all rise. Very funny, Charlie. Got my pickles delivered to my door today. I am Ami 008. Please refrigerate them appropriately before you consume them. They are fantastic. Yes, Sarah Boone's going to be a lot of fun. That's going to be a fun trial. Not for her, but just for spectacle purposes. The jury won't go back and watch the Out of the Eyes of the Jury stuff, but they should. While we're at lunch, please do not touch or rearrange your setup. Sharon, I'm not going to switch anything. I'll do a test probably tonight on StreamYard and try to get that working. Maybe for the podcast on the weekend, but I've got to figure some things out first. What's going on with the Visine murder trial? Did they select a jury yet? I think they did. I think it's in progress. I have not followed it yet because this one's been going on. Sarah Boone was unintentional. Not intentionally Sarah Boone. Goodman Law, you have info on the email. What's the info? What do we have? Let's see. Do you want to connect, or what's the status there? Should we just watch in chat? Just 1 second here, trying to get everything set up. Okay. Share the info about the email. Can you spill the tea? What do you know? Chris Wilson emailed the court. Dun, dun, dun. So what did he say? What did he say? You need your own channel. I've told her this as well. I can help you get it set up. I'll give you some advice and everything. Do we have any information on what Chris Wilson emailed the judge about, if that's what happened? Let's see. Let's see. It might have been backstory. There's a famous whoop shotgun that would belong to a hunter, author, or conservationalist in the early 1900s. We need to spill the tea emoji. Little Miss says, Goodman Law Firm, call in now, please. Chris Wilson emailed to say someone violated the jury identification order from the judge. They doxed a juror, and yes, you can help me. Oh, man. Doxing a juror. I think this is one of the concerns I had about the jury going on a field trip. The possibility for just members of the public to take pictures and be in positions where they can see what's going on at Moselle or on the way to Moselle and say, hey, here's a new face. Who's this person? That's a juror. Yeah. The case is a mess. He's the one who emailed the court day 2 saying someone contacted him with jury information and names. That was never further addressed to my knowledge, says Lindsay Hendricks. Let's just see. Everyone is aggressively throwing their iPhone to see if it lights up. Phone sales are going to surge after this week in court. Doxed a juror means doxing is when you release someone's private information in a public platform. Generally, it's someone who is not a political figure, someone who's not in public office. It's basically anytime you let the jurors' names out in public, whether it be in a publication, on a video, in a tweet, it should not be made public. Their names should be secret right now. And just that's one of the reasons that the judge says, the cameras cannot show and face the jurors. They can't capture any of those. They're not allowed to report on who they are if you do find out who they are. Charlie Peterson, snow blowing over lunch. Charlie, man, you've got to come visit, man. It's 73 degrees here today. It's beautiful. Instantly retrial fodder, taken very seriously. How many phone injuries are going to occur today is what I'm wondering. And do you have suit against me if you do throw your phone and it breaks and hurts you, because we've talked about it so much today. Lost connection to RA. Oh, no. I'm still here. I think they will move for a mistrial. We'll see after lunch. Imagine attorneys have post-arrest remorse if not asking better questions. How many different phones did he throw? I want to know if the phone broke at any time during the throwing. Would that influence how it performed afterwards? I wondered if it's something to do with that again. We all have worries with the field trip in that matter. I'm curious if it's if it's the same email or different, newer. 85 in Orlando. You got me beat. I missed everything. I'm sick at home with the stomach bug. Susan, I'm sorry. Please get feeling better. Get some rest. Oh, man, that is no fun. We're on lunch today. We're going to come back at 2 o'clock. We're just wrapping up here. They're trying to figure out what happened with the letter that went to the judge that he just gave copies of to the attorneys. Let's see. I'm looking to see if there's any information about that email. Okay, I'm not seeing the email anywhere. I want the contents of that email stat. Okay, so we'll probably look for it after lunch. 34 in Pittsburgh. Oh, that's cold. 6 centigrade in Cambridgeshire. Couldn't that be a crime? Couldn't that use Chris Wilson's email to source back to who sent it, similar to sourcing back who called in bomb threat and charging there? I don't think Chris Wilson's email is just going to basically say, hey, I saw this online that somebody doxed one of the jurors. And it's probably going to be like a... It's probably going to be something that's not like direct doxing. I doubt anybody went to the courtroom and found somebody's name and said, I know who that is, I'm going to publish the name online. I don't think it's going to be like that. It's going to be maybe some information that's probably more leans towards identifiable information, but not actually like, here's the name, age, address of one of the jurors. Hubby just brought home some chocolate frosting and French fries to help ease my pain from the fall last night. Amber, sorry about the fall. That's no fun, but frosty and French fries is a good way to go. Mrs. R.A. would be proud. Okay, here's what has to happen. I'm gonna take lunch because I got to throw my phone a few more times. I'm way behind on the phone throw count. Let's see. From my understanding, it was someone Chris Wilson knew who sent him juror information at the beginning of the trial. I do know there was one juror whose brother was on witness list. 32 freezing t-shirt weather in Utah. T-shirt weather is when it's freezing cold outside but the sun's shining, so it feels warm. Heat wave in Minnesota. The ice is almost melting. All right, let's go to lunch. Let's get some lunch. Let's get some food. I won't touch anything. I'm not going to break anything. Okay, so we're not going to have the problem we had this morning. I'll fix that in my off hours. But it's spicy. We have one more witness, and then we could have an early break because the jury is going to go to Moselle. So that might be this afternoon. Depends how long this doctor takes and how long cross and redirect and recross is going to take. And then we're going to see. Then we're going to see if there's what do they call it when there's rebuttal? I forgot the word. But the defense offering rebuttal to what the prosecution offered as rebuttal. It could go on forever, layer upon layer. You know it. You know it will. All right, guys. Stay warm for those of you that are cold. For those of you that don't like the cold, come to where it's warm. It's great here. I'm gonna pour some Coke over my legs, see if worms come out. Bill. Oh man, fun conversations. You guys are amazing. Thanks for spending your morning with me. Hope you have a great lunch. If you are not able to come back for the rest of the day, which might be short, might be long, we're not sure. Please, when you go home tonight, hug the people you love, smile at someone, make their day just a little bit better, and please stay safe till we go live again. We'll be back at 2 p.m. Eastern time. Gives you about 45 minutes for lunch. We have a little break. And we'll be back here for the remainder. It might be the end of testimony for trial. We could be moving on to the next phase. Verdict watch is just around the corner. We'll see you guys.